All right. Good morning, everyone. This is day 6. It is October the 8th, 2024. We are back on the record in the matter of Miss Joanna Stolar versus State of Wisconsin Department of Corrections. And case number is CR 2020-02513. On behalf of the complainant, we have counsel, attorney Ben Hitchcock Cross. For the respondent, counsel is still the same. We have attorney Olmanson as well as attorney Card and paralegal Mr. Ross. Okay, we are still on the respondent's case in chief. Who starts us off today?
Judge, I'm going to have a few things that I got to get on the record here.
Okay.
Great. So I was just outside having a conversation with several state of Wisconsin staff and the police officer here. This is Rusty. I'm not entirely sure what division that he works with, but I understand that he is the supervisor of Tina outside. When we initially got here, we have been back in this room where we were at on Wednesday last week. This is the same room that we were in. I'm extremely uncomfortable being in this room because this is the room in which Andrea Olmanson called the police, and the judge, that was fine with her. And this was calling the police regards, just so we're all clear, judges, I'm going to make a motion and say very similar things to what I said on Wednesday, and I'm going to have a motion for sanctions based on that. So I want to be clear that we're going to say we're going to have similar comments to what we had before. So I guess it's lucky here that we have the police, but just so that everybody's ready for that, because...
before we get started...
No, Judge, I'm making my record here, excuse me, and I need to be clear because I've got these statements that...
I understand you're making a record, sir, and I will allow you to make a record. I have no problem with that, but I want it clear that if it's the same motion you've made orally and in writing and the same comments, for the sake of time, we can't keep making the same motions over and over again.
Great.
Okay?
Thank you.
I'm not done.
Okay.
And we were in this room on Monday of last week, on Tuesday of last week, and on Wednesday of last week. I don't assign rooms. I don't know who does. I just go where I'm told. I stay in my lane. For whatever reason, we are back in B103. That's all I can tell you. So it's the same room we used on Monday, Tuesday, and Wednesday. I want to make sure that's clear. We were moved on Friday, yesterday, to another room down the hall that was larger. Please continue, sir.
Great. I think it's inappropriate for you to interrupt me when I'm making my record to make your own statement.
Well, we have to be clear that I don't want to hear repetitive things that you've already said.
Great. I heard that.
Good.
Thank you. Okay. So then, in my discussions with Rusty there, we had to go, and there's an officer in the room, his name is Hyatt, A. Hyatt. This was witnessed by him. We had a series of conversations because I asked him why we were in, I told him that I was uncomfortable being in this room, again, because this is the room in which I was surrounded by police, and Ms. Olmanson called the police while I was making what I understood to be a legal argument, and that is fairly traumatic for me. I think I had put that on the record several times here, and to be clear. So I talked with Mr. Rusty again, I don't know his last name, and we had went round and round several times on why it is that we had to be in this room here. He for many times told me that this was the only room that was available to meet our needs. He met with the calendar. He explained that there was a calendar issue, that this was the only room that we could reserve. I asked him about why what calendar, what documents would show what was available, and we went around and around like that. Finally, he divulged to me that this room has a button in it that allows the judge to contact the authorities because they, which is Rusty and apparently the Department of Workforce Development, is worried about me and my threat to safety, apparently, that it believes me to be. This is, I guess, more continuation of what apparently we had heretofore, which is why the police were here. And we've had all sorts of reasons coming from the judge, coming from the police. But finally, I think Rusty let the cat out of the bag here, and out of frustration, it appeared that he divulged these facts here. So I need to put that on the record here. Obviously, this is further indication of bias, prejudgment, and really collusion against the complainant here. So that needs to be put on the record. I also have a motion when you're ready.
Go ahead.
Great. So we are going to move for sanctions here. The defense has, or I guess the respondent has maintained a frivolous defense or argument in that it sent to me, as I read out here, in March, a letter stating that Kevin Carr knew nothing about this case and did not participate in it, and they quoted the shocking rubber stamp decision from ALJ Gelhard, this tribunal's predecessor. There was evidence here so far in the hearing, and I just want to make a contradistinction between their motion for sanctions and what we actually discovered here, is that Carrie Beyer told us, confided in us, testified that Kevin Carr in fact knew the facts of this case, as explained to him by her, that Kevin Carr just weighed the pluses and the minuses, knew what was, had other discernment, and made a decision. And that also was testimony that these two attorneys consulted with this person and were apparently aware of these facts. That, I think, is really the issue here, is that they have continued to maintain what also in their motion, in the response to the motion to compel in the first place, which is this defense that Kevin Carr, is simply a rubber stamp and knows nothing. And that we submit is grounds for sanctions and attorney's fees, and that the complainant should be made whole for her costs and her fees for having to respond to these frivolous defenses, or I guess knowingly false defenses that these attorneys asserted, namely that Kevin Carr, and I want to be clear, Kevin Carr and Amy Petchacek's affidavits appear on their face to be truthful, according to what Carrie Beyer had said. And so I'm not asserting that. What I am asserting is that, particularly the Olmanson letter of March, I believe it was 25th, that is, for lack of a better word, a big fat lie. And that, I think, needs to be addressed here. That's why it's our argument that that was frivolous and that they knew that to be incorrect. We point out that there was testimony from Ms. Beyer that she met with these attorneys, or at least Ms. Zacard, for the previous hearing, which was held in January, that is before March. So on that basis, we submit that they have propounded a theory, a defense that is false and knowingly so, and therefore for justice sake, they should be required, ordered by this tribunal to reimburse the complainant for her fees related to that. Thank you.
And do you have a statute that allows me to do this?
Well, absolutely. It's the same one. It's the frivolity statute, which I believe is 22.
Okay, that's what I wanted to make sure, that we're referring to 227.483.
483, yes, ma'am.
Okay, that's the basis of your motion, all right.
And let's see, I'm looking at a letter here dated March 26th and a letter dated March 27th. Is there a letter dated March 25th? If there isn't, what are we talking about here? This is the complainant's motion.
Okay.
Is there one in the file?
There is one in the file, and I've sent this to you. I've also read this out here in the record, and we put that it's March 27th. I'll be happy to. We put it in the record on Tuesday of last week as the rebuttal evidence against Carrie Beyer. And
That was that the email that you sent?
Yes, and that's
Okay.
March 27th of 2024.
All right, it's in the file. Hold
Right.
on one second, because I need to make reference to all these things, because I got an email from you with an attachment. It's in the file. I put it in the file. I just don't know what I'm supposed to do with it, because it was October 1st that it was
Sounds
sent.
good.
So let me take a look at this and see if this is what we're talking about.
And Judge, I'm sorry, for the record before, I want to make clear that Rusty also made direct comment to my participation in YouTube along with his statement, and that was because the threat and the YouTube comments, I think, were sort of coextensive there, and I think that needed to be clear.
Do we know who this Rusty person is?
He's Tina's supervisor. That's who we know that is, and he's the
Okay.
person as you told us that Tina is the person that told us that this was the room that we had to be in. Rusty is their person supervisor. I know they don't work for the Department of Workforce Development. They work for some other. At least they don't work for the Equal Rights Division. They may work for some other division in under TWD.
Okay. I think they're in charge of the building.
That would probably
That
be Department of
department.
Administration, but
Or, I don't know.
okay.
Okay, because the email attachment that I have to your email that you sent on October the 1st is simply the respondent's brief in opposition to the complainant's motion to compel discovery in support of its request for costs.
And when was this sent?
He sent this on October 1st. It was last week.
Okay.
Right, and to be clear for the record, I understand this to be this 3-page letter from March 27th that I believe I introduced into the record as rebuttal evidence to Carrie Beyer. So that would have been the second, right, the Tuesday. Because
I'm just...
My recollection is we had the discussion about it Wednesday morning, and then the respondents called the police. So that's how I'm basing my understanding on that. Tuesday's also the day we stayed late in favor of Mr. Grabinski.
And just a sec here. I'm trying to find something that was sent by Attorney Cross on October 1st. Is that correct? Oh, I see. Here we go.
Yeah, it's just, all it is an email with an attachment.
Right, the March 27, 2024 letter.
No, the attachment, that's what I'm trying to explain.
Okay.
The attachment is simply the respondent's brief is what you attached. It's
Oh.
88 pages.
That may have been reference to something else.
I don't know. It's
Okay.
just in the file
I've
because
sent the March 27th email now directly. But it's my understanding that we not only discussed it, it was entered in the record, and I confronted Ms. Beyer about it.
Okay. Was it an exhibit?
As an exhibit, yes.
Oh, well,
I asked
okay.
it-
All right. Well, hold on a second.
Oh, I'm sorry.
Because
I
I'm
thought
going from
that's-
emails to exhibits.
I'm
It's
sorry,
like
Judge. I thought
no. I just want to.
Vocabulary is key, I know.
I just want to be clear to make sure what we did. So it's got to be one of your exhibits.
Yes,
Okay.
ma'am.
All right.
Tuesday.
So, all right. So we have complainant's first exhibit was the interview regarding Alicia Miller. Then we had the Stephen Grabinski interview was number 2. Complainant's third exhibit was the DCI FLIC pick fishing tournament. I think that was the email that went out, or the page of that. The fourth exhibit was the Teuton investigatory packet, and then page, I think this is what we're looking at, C5, so that would be 1059 to 160. So let me find that, please, to make sure. All right, so let's go look for that, because I think that's what you're talking about, sir. So
That's right.
just give me 1 second, okay? Let's see. All right. Page. Hold on. 1059. So that's actually, it's one of your exhibits. It wasn't one of the respondent ones. All right, complainant exhibits. Okay, let's go through this. 1059. It's an email that was sent by Captain on October 1st at 4:42. The page begins, "Dear Attorney Cross," and ended for emphasis added. So it's got to be an email.
So
Hold on. Let me see if this is what I have found. Those are my notes for it, okay? But for some reason, the numbers aren't matching. That's why I'm looking for the respondents.
If there's no objection, I can just show you the page here, and that'll have those two things that you're talking about. So here's the Dear Attorney Cross part, and here is the emphasis added part. So I believe, again, it's this March 27th email.
Okay, but I'm trying to find what the,
I totally get it, but hopefully that'll help you.
yeah. Because I believe I have the Bates number written down incorrectly.
Well, no, this was, he showed up with a brief and started to cross-examine Carrie Beyer about it, and it wasn't part of his exhibits that he had initially submitted, nor was it part of DOC's exhibits, and so it was just given these Bates pages.
That's what it was.
Rebuttal, right.
Okay. All right. So, okay. I need to make a note of that. Not submitted as exhibit rebuttal.
I think, is it on pages 3 and 4 of this brief?
It might be. Number given by ALJ. Thank you all for refreshing my memory, because your numbers ran out, but it was something you were using, you cross-examined her with, so that's what I'm trying to figure out. You think it's on which page of your exhibits?
Oopsie, just a sec. I think it was, it started on page 3. And then...
Wait a minute, of your exhibits?
No, it's
No.
not an exhibit.
It's not an exhibit anywhere, right?
Right.
Correct.
It started on page 3 of this brief.
Of which brief?
I'll forward it to you.
Is it the one that he just emailed?
Let me see here. It's the one that he would have submitted, he emailed on October 1st.
Okay, great. That's all I need to know, because I need to make sure that now that I know what this is, I need to,
And
all right. Let me open this attachment up, because I want to make sure that, so this is the brief, and within this respondent's brief is this letter that you're talking about. Do I have that correct?
That's my understanding.
Okay, then let me.
And that would have also been the brief that I had referred to in my motion.
Well, okay, I want to make sure it's properly labeled for the record,
Great.
because I think it needs to be very clear, not only in Chris, what it was that you were referring to, and since I gave that a Bates number, so now I'm trying to find that specific letter in this brief. Or, which might be easier, is if you could just email me that.
I've already done that in the last 3 minutes. I think I just emailed it to all the parties, and I got a bounce back notice from one of the opposing counsel, so I assume you have it.
Okay, well, let me check my email.
which of the opposing counsel do you claim you got a bounce?
Well, if you guys were out of office because we're in the middle of a hearing, that's what's going to happen. It's there. You've got it. He sent it to both of you.
Okay.
I obviously am not going to get a bounce back, but usually that's what happens if you set your calendar that way so people know what you're doing. Okay.
Yeah, I just asserted
Oh,
a proposition that it was,
my goodness, this has been in the file a gazillion million times. Attorney Cross has submitted this in one of his motions as an attachment. I've seen this letter. I know what we're talking about. Okay, I need to make reference to this for when I copy it over into Chris. Letter and email 10-8. Reference to motion by Attorney Hitchcock Cross on oral motion on 10-8. Same letter page 1 is complainant exhibit 5, given Bates numbers 1059 ends at emphasis added. Okay. Okay, I have it. I think we all have this, and this was, this is the basis. Sir? This is the basis for what you have said, that they knew about it, they
asserted a defense.
asserted a defense of the theory of the case, or a defense as to why, as it pertained to Mr. Carr.
That's right.
Both?
Both.
Okay, I just want to make sure.
Thank you.
Defense as to case and as it pertained to former Secretary Carr. Okay. All right. Does the respondent have anything they wish to say in regards to this?
I would like the opportunity to provide a written response. Maybe in conjunction with post-hearing briefing.
No, it's not going to be in conjunction with post-hearing briefing. If you're going to give me a written response, I'm going to need that, because I don't know how many witnesses you plan on calling today. I don't know if we're even going to be done today. But if you want to respond to this, I realize this is a very short time. Maybe that could condense your response to just critical things that he's mentioned in his motion, as opposed to the kitchen sink, because as I see it, he's basically saying you guys provided false information in regards to the defense of this entire case, as well as it pertained to Secretary Carr, although he also said he has no reason to doubt Secretary Carr's affidavit. So, but that is the motion, and he feels that doing so rose to the level of a frivolousness, and therefore he's also asking for a 227.483 motion. So that's the only thing I want you to address in response to those claims that he has made. Okay? And today is Tuesday. I will give you, you're just going to get a couple days. So this is going to limit how much you're going to write, and we're not going to send me 755 million pages.
Judge, it is discretionary. I mean, it's an oral motion.
Right, but I'm going to take it under advisement, and I don't have to issue a ruling at this time. A 227-483 motion only.
I think I'm just pointing out that it's discretionary, allowing them to write something.
Yeah, and I'm going to allow them to do so because it's 10 at 10, and I would like to start taking testimony.
I understand.
So, you obviously gave this a great deal of thought, and how you came to this motion. I would like to give them an opportunity to put a great deal of thought into this as well. But I just have to have these motions made prior to any finality of this hearing and any decision. Any decision I render will be incorporated into that final decision.
I understand.
That's what the rules for 227-43 tell me to do. I'm looking at the calendar. I don't know what your schedule is, but I'm going to give you no later than 4:30 on Thursday, the 10th. Okay? That's till 4:30 on October 10 to submit response to oral motion adhering to just the issues raised. Okay.
Judge, do you have any statement about whether or not there is a, lack of a better word, a button in here to call the police, and whether or not the police are here for me as opposed to the responding counsel, or anything along those lines?
I have been informed that there is a panic button in every room. There is one in this room. It was attached to that table over there. That had been moved into the other room. It was removed off of that table. Basically, it's for Capitol Police. I didn't request a button. I haven't requested a button. But I was informed that there is one. I'm the one, as I've told you, did request to have security here during this hearing, as I do during all hearings. It doesn't mean somebody is required to remain in the room. I have every right to do so. It is something that I did, and I've acknowledged that. It is what I did, and I have that right. And I wanted it for maintaining, as I stated, decorum. I find that having the presence of security I don't have a bailiff or somebody like that. When I asked, they said there's Capitol Police, and I'm like, whatever. I don't care, whether it's Capitol Police or Mr. We rent security. I don't know, but I like the presence of somebody. It helps for the sense of decorum, and that's why I do it. And I have every right to do so. I always have to arrange for security if I feel it's necessary. And Lurk has even said that that's perfectly acceptable, and I always have that right. So that's not really an issue. It's for everyone. I don't. Sometimes witnesses get out of control. That's usually the case. Is it's more of a witness. I've never had an attorney ever be disruptive at a hearing in my entire life, whether as a practice attorney, whether as as an ALJ for UI, whether over here, even as a sitting circuit court judge. I've never had an attorney get disruptive. It's always been the witness, or whether it's defendant, or maybe in a family case, it's one of them goes at. Family cases can be extremely volatile for a variety of reasons. Is it specifically for you? No. No. Was it specifically for one of the respondent? No. I don't know who the witnesses are. I don't know how volatile this is going to get. I don't know. So just for the sake of decorum, that's what I do. Am I in fear of my safety? No.
I appreciate you putting it on the record. Judge, just one last thing. I've had several conversations with police officers who seem to know about the YouTube channel, and Rusty now just made a reference to the YouTube channel, and I'm just wondering if there's any connection between those.
I have no idea about the YouTube channel and whatever. I've never watched their YouTube channel. As you know, there have been numerous briefs and mentions of it by the respondent, and if you read any of my decisions, I never touched on it because it's immaterial as far as I'm concerned to the issues. It's minutia, and I've told both you parties I will not entertain gratuitous comments, arguments, things that have no bearing on the ultimate issue before me. It causes a distraction, so I won't. And the only YouTube I watch, as everybody knows, is when I'm depressed or had a stressful day. I'm looking to look at baby goats, because if a baby goat can't make you laugh, there is something wrong with you.
I thought goats in pajamas too.
And yes, there is this woman that literally just puts goats in pajamas and does videos for them. I encourage anybody who's had a hard day, look for goats in pajamas. And they're baby ones. They're really cute, and they've all got little match, and they hop out of the. But that's the extent of YouTube. Okay.
All right, and I appreciate that, Judge. I just wanted it on the record, and I'm done now. Thank you.
Okay. All right. So that's it for all of this morning. I'm going to make note. It is now 10:15, and if the respondent's ready to go, I don't know if anybody needs a break, step away, or whatever. I'm more than happy to give anybody one. But otherwise, if we're ready to go, if you could call your next witness and let me know who that's going to be, that would be fantastic.
Okay. It'll be Craig Theander.
Who? Craig Theander. Okay.
Could I use the restroom since you
Okay.
offered?
All
I'm
right.
sorry.
This is what we're going to do. Let's everybody just take a. All right. It's 10:15. At 10:30, if you could have. Hold on. Let me get his name again. See, now all my pages went away. Okay. Yeah. I'll pull up your witness list again. If you could just have Mr. Theander
Yes.
in here ready to go in that chair so I could swear him in at 10:30, I would be forever grateful to everyone in this room, because I really, really, really want to get going. All right? Thank you, everyone.
I'm going to leave this door open.
Whatever you'd like to do. Okay. Okay, we are back on the record in CR 2020-02513. Appearances are the same. We have respondent's first witness for the day. I believe your name is Craig Theander?
Yes, it is.
Good
I believe
morning.
it is also.
Sorry about that, sir.
No,
Okay, it was good. It was a good one. You made me
Yeah.
chuckle. All right, so if you could please raise your right hand. Do you affirm or swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. You may lower your hand. Before you get started, there's something I like to tell everyone, and sometimes I forget and then I interrupt. So now that I remember, it goes kind of like this. If there's something you get asked by anyone and you don't understand their question, because sometimes it happens, I even ask them. Okay, so by all means, just say, I don't understand what you're talking about. Could you
Yeah.
repeat it or clarify it or something? It's perfectly acceptable. Also, nobody wants you to guess, okay? So, an acceptable answer is, I don't know, or I don't remember, or I don't recall, okay? So, no guessing, no whatever. We just want to hear from you as to what you do know, and that's that. Now, who... Because we don't double team, okay? So you got two over here and one over here. So we have to pick.
I will be doing direct.
Okay. All right. So Attorney Zacard, your witness, please.
Thank you. Good morning. Could you please tell us how you're employed?
How I'm employed?
Yes.
With the Department of Corrections. Maybe I'm assuming that's what you mean. I'm a captain at Dodge Correctional.
How long have you been at Dodge Correctional for?
Just recently, about almost 5 years, I believe. I mean, with the Department of Corrections for just over 12. I started as Dodge as an officer and a sergeant, and I worked at Oshkosh and Waupun, and I think I came back to Dodge as a captain 4.5-ish years ago, I
Okay.
think.
Were you employed as a captain then in 2020?
Yes.
Okay. And I see you're wearing the white shirt.
Yeah.
And is that typical of supervisors wearing the white shirts?
Yes. Yeah.
Okay. And what are the blue shirts?
Yeah, sergeant or officers, blue shirt.
Okay. Are you familiar with a person by the name of Joanna Stolar?
I do recall her, yeah. Yes.
How did you know her?
She was an officer when I was there as a captain.
Okay.
Excuse me, and you did say you're currently at DCI, right?
I'm currently there, yes.
Okay, all right.
Thank you. I probably should have asked this before, but could you tell us about what your job duties are as a captain?
Then or now? Because it's a little bit different.
Okay, so how about you tell us about back then?
Back then, I was, I don't remember the exact year. I was either second shift or first shift line captain. Because I was one for a little while and then first shift for a little while. I don't recall which shift I was in 2020.
Okay, what is
But that aside, as a line captain, you're responsible for a lot of the overall operations of the institution at that time period you're working. Safety for the inmates, safety for the staff, making sure, basically, in general terms, that it runs the way it's supposed to run by policy.
Okay. And now you are still a captain, but your job duties have changed?
Yes.
What are your job duties now?
I'm currently the training captain, so if I'm helping online, I'm responsible for that, but I'm responsible for training for officers and sergeants in the institution.
Okay. is that training that occurs after maybe new people transfer in and have been trained?
All of the above.
All of the
A
above.
lot of it's focused obviously on new people coming in,
Oh.
responsible for that, but also ongoing training for current staff, mostly for the uniform staff, but also to oversee some occasional training for non-uniform staff as well in the institution.
Okay, thank you. And so, do you recall an incident that occurred or incidents that occurred at, strike that, let me start over. So did you hear about some incidents that occurred at a fishing tournament back in January 2020?
I wasn't present then. I mean, did I hear rumors about stuff? Sure. Not there at that time.
What do you mean you weren't present? You weren't at
I was
Dodge?
not. I was at working, but I wasn't at the fishing tournament.
Okay.
I wasn't there when whatever happened.
Okay. Now, you said you heard some rumors about it. What kinds of rumors did you hear, if you recall?
I don't recall. I mean, there's a lot of rumors that go around, unfortunately, in corrections. I try to stay out of that. And to me, they're just rumors.
Okay. Did you recall hearing any rumors about Ms. Stolar?
Rumors about everybody.
About
I
everybody?
mean, people talk about people right or wrong.
So, you did actually work with Ms. Stolar at times?
Yeah, she was. She was Unit 20 officer when I was there. I believe. I don't remember if she was first shift or second shift, but I know she was a Unit 20 officer then.
Okay. Did you have face-to-face contact with her during the time that you were both at Dodge Correctional?
Sure, if we're doing rounds or checking on the unit or dealing with issues on her unit or anywhere institution when she was working, sure, yeah.
Okay. Did she ever report to you any complaints about hearing rumors about herself to you?
Not that I recall.
Do you ever have staff that come up to you report that they've heard rumors about themselves from other staff?
Oh, sure. Yeah.
Did Ms. Stolar ever tell you any rumors regarding, and actually strike that, first I would like to know, do you know who Jason Toutant is?
I know who he is, yes.
Do you know Alexander Hartzheim?
Yes, he currently works there.
Okay. Do you also know Lieutenant Miller?
Yep, she also currently works there.
Did you ever hear any reports from Ms. Stolar regarding any of those three employees?
No, I don't recall, no.
Did Ms. Stolar ever report to you that employees asked to see her breasts in the institution?
No, not that I recall. If that would have been brought up, I'd take any kind of sexual harassment pretty serious. If that would have been brought up, I would have handled it appropriately, or handled it accordingly, and never file a harassment claim.
Okay. So what do you do in terms of filing harassment complaints?
There's a policy for that. There's an intake process. So you either yourself or you have them sit down with a supervisor. It can be a uniformed person or it could be a not uniformed person, whoever. Like if this person's saying, hey, this person's harassing me, who asked me if you want to go intake, and either they can say yes, or if they say no, but we feel it is to the level of harassment, then we will do the intake anyway. Sit down, get that person's side of what happened confidentially. It goes directly to the warden, and he reviews it and makes a decision on where does it go from there.
Okay.
I've done several of those. I've never done one with Stolar. I've never had a complaint that way, but I've done several intake ones, yeah. for those reasons.
Okay. And, did she ever approach you regarding other issues or conflicts in the institution, just in general, or ask questions of you, if you recall?
I'm sure she probably did, because a lot of people ask, being a supervisor, a lot of people ask us a lot of questions, what they would have been, to be honest.
Okay.
That was quite a while ago.
Okay. Are you familiar with Nick Farley?
Yes.
Okay. Did you actually work with him while he was still there?
For a short period of time. Yes, he was a supervisor when I was there as well.
Okay. Did he ever make any reports to you regarding staff targeting Ms. Stolar?
Not that I'm aware of.
Okay. If Ms. Stolar had approached you with some concerns about harassment, would you have followed the policy that you had
Yeah,
alluded
absolutely.
to? Okay. Do you recall how Ms. Stolar left the institution? I can rephrase that.
I wasn't privy to why. I mean, you obviously hear people talk about a whole bunch of things that I don't listen to. Dodge is very good at keeping investigations private, confidential, so the reasons why, I don't know if she was terminated or if she quit, but the reasons why she left, I do not know.
Okay.
If I recall, I think she resigned, but I'm not exactly sure.
Just out of curiosity, do you know about how many employees there are in terms of uniformed staff at Dodge?
About just shy of 400. About uniform staff, I think we have like upper 300, close to 400.
Are there staff there now that you don't know?
Well, yeah. I mean, you're there, so I know them by face, know them by name, because we do check-ins, so you have to check in everybody's name.
Mm-hmm.
But obviously, there's some I have a fair amount of, quite a bit of contact with, and there's some that I know who they are, but probably if I saw them out of uniform at a Walmart somewhere, I would have no idea who the heck they are. Or I don't, they work a different shift than I do often, don't pick up overtime, I don't interact with them at all, but when they come in the door in uniform, I'll be able to check them and I know their name and who they are. So I probably know all, at least by name and face when they come into the institution, all the uniform staff and probably most of the non-uniform staff.
Okay.
Can I answer your question? I kind
Yes.
of rambled on a minute.
No,
but-
no, that's okay. That makes sense. Now, you had worked at a couple other institutions as well. Were there rumors that were going around in the other institutions? Is that something that happens at not just Dodge, or is this kind of a...
That's life.
Yeah. Okay.
You go on Facebook or whatever, which thankfully I don't have Facebook, I don't have Snapchat, I don't have anything else, I don't even have a cell phone. So, unfortunately, people talk about other people, whether it's true or not true, and does that happen at corrections? Yeah. But I'm pretty sure it happened when I worked at Children's Hospital for 20 years. It happened there too. It's not okay, but it.
Mm-hmm. Sorry, 1 second here. Oops. Just to kind of clarify, so you indicated that you've had employees come up to you and complain about, they're hearing rumors about themselves. What, if anything, do you do to offer suggestions to them?
I take it seriously, so you try to find out exactly what the truth is. So somebody might be hearing, say somebody saying something negative about another staff member. You try to talk to them and say, pull them aside confidentially, where there's usually just me and another supervisor and that person, and say, so what did you hear, or what's going on? Sometimes it's, well, so-and-so talked to so-and-so, who talked to so-and-so, who talked to somebody else, 5 people down the road. But if it is, and sometimes it's something that you can say, okay, you assess that situation, just like we do with other stuff, and you look at it and say, okay, this is what you're saying, this is what's happening. Do I need to follow up with it more? And find out exactly what the truth is and talk to those other people. It's something fairly mild that doesn't meet the level of harassment. They just don't like what somebody, that while they were saying, I'm not doing my job, okay? Whatever that happens to be, you look at it one way and handle that accordingly. And then some people bring out some things that are more serious, and you'd be able to investigate that and talk to the other staff members, and whether it be doing an intake, because somebody's feeling being harassed, especially if they just say, hey, I feel that I'm being harassed, I feel I'm being sexually harassed, physically harassed, whatever it happens to be. Then we pretty much, for myself anyway, I would always go towards the intake part and let the investigation people handle it the way it needs to be handled. But you try to do an investigation, at least find out the facts before you deal with it accordingly. So try to give you a roundabout answer, but you try to assess that situation and determine what's the best way to resolve the issue that's going on.
And you had indicated that they usually try to keep all the investigations private and not talk about them.
Yeah.
Did you hear anything about Mr. Teutons at all, if you recall?
I hear that he was in trouble because he was obviously sent away from our facility and was over up a pond. The specifics about it, again, I wasn't there. I can't speak on behalf of it at all.
And do you recall Ms. Stolar ever reporting any unwanted contacts by either Mr. Hartzheim or Mr. Teutons during 2020 when she was there?
Not to me, no.
I don't have any further questions.
Great, maybe I can ask some. How do you feel about that, Judge?
That's fine. Begin your cross, sir.
Thank you so much. All right. Have we met before?
I don't think so. I don't think I met anybody before. That matters.
All right. How did you prepare for your testimony here today?
Nothing.
Nothing? You didn't look at any documents?
Not that I recall, no.
Okay. Now,
I didn't have any documents to look at.
appreciate that. Correct me if I'm wrong, but I thought I understood you to say that you didn't hear any rumors about Stolar. Is that true?
Correct.
Okay. And were you, let me ask you a different question then. Were you ever aware of Stolar complaining about any rumors?
Not to me, no.
That's not my question, sir. My question is, were you aware of Stolar making any complaints? And can you answer that question?
I guess I don't understand your question.
Well,
you
you
asked me, did she bring up any complaints to me about harassment? And my answer was no.
No, I didn't say that. My question to you is simply this. Are you aware of any complaints? You keep responding, and I'll just wait for me to finish my question. You keep responding and say, am I aware, answering as far as I understand, are you aware of any complaints that she made to you? I'm not asking you that. I'm asking you simply, are you aware of any complaints? Can you answer that question?
I mean, not really.
Well-
Because I guess I don't understand. I mean, I'll speak on behalf of what I know is true. And did she make any complaints to me about anybody? No.
Why do you keep inserting the word "to me"? and your response.
I would
Because that's
object,
what I know is true.
Okay.
I'm not
Can
going
I-
to speak on behalf
Can you
of
wait?
somebody else talking
Wait.
about something else.
Wait, let me object.
Yeah.
Okay, that's argumentative. I think he's not understanding the question, and I would
Yeah,
ask that it be rephrased.
I don't think he understands the question too. The first one was, did you hear any rumors regarding her? And your response was, no, you did not. His next question is, are you aware of any complaints that Ms. Stolar made? You either are aware of them. He's not asking if you
I guess
participated
I
or
have to say
anything.
no, because I'm only aware of complaints made to me, so no.
Okay,
Okay.
that's what he was asking.
Yeah.
Now I understand. Okay. And you know who Alicia Miller is?
Yes.
Okay. And did you ever participate, by participate I mean give any either testimony or interview anybody in regards to Stolar's complaint against Alicia Miller?
I'm gonna
No.
object.
I never did an investigation.
Okay,
Oh.
all right.
I'm sorry.
Okay. Okay, I forgot to go through this part too. I own it. All right. So basically, what happens is one of them will ask you a question,
Stop for a
and
minute.
yes,
Okay.
think about the question, answer only the question. But before you just jump right in, one of the other attorneys may say, "I object."
Okay.
Okay?
Fair enough.
And then everybody's got to stop because then I need to hear the objection. Then I need the other person to explain why it's not an objection. And then ultimately I decide.
Okay.
Okay? So
Okay.
the question was, do you know Miller? You said yes.
Yeah.
Now, what was your next question, Attorney Hitchcock Cross?
Well,
Something
I
about
asked
it.
him and
Something
was
about an
objected.
investigation. I know, but I want to hear the question again because he was speaking, and then I had an attorney trying to make an objection.
Well, she didn't actually make any objection. But that was what actually happened. But I will try to start to rephrase my question again. But I think this is just interruptions here. Well, you can sigh, but it may be more appropriate to actually make an objection or a legal argument or cite to some statute, constitution, or rule in support of your position, as opposed to merely sighing or saying objection.
Well, we haven't gotten to that part
Right.
yet because when somebody says an objection, but he was, I hadn't instructed Mr. Captain Theander
That's right.
properly. So I'm going to take blame for that. Okay, I
Okay.
own my stuff.
Great. So I'll continue then. Thank you, sir. You're telling us here today that you didn't participate in any way in the complaint that Stolar made against Miller. Is that true?
Objection, this is outside the scope of this hearing. I thought we were not getting into.
Well, we weren't getting into any investigation regarding Miller. Those are the question numbers or the complaint paragraph numbers that we had said were out of bounds for the purposes of this hearing. I think he could rephrase that question in regards to what we are here for.
So,
And see if
Judge,
he
they
partic-
asked those exact same similar questions. He said he didn't know anything about it. They asked him about Miller. I mean, come on. It's one rule for them and another rule for us.
Knowing's Miller, I allowed you to ask that question whether he knew Miller. It's the same one they did. You asked it again.
Right, and now
So I
I
allowed
asked
that.
him if he was aware of the he participated in this investigation, and he's saying he doesn't know anything about it. So I'm asking him whether he participated in this investigation, and they're saying it's outside of the bounds. It's getting outrageous again. It's one rule for them and another rule for the complainant.
Well, I disagree, and the record's going to speak for itself. Question was, did you participate in any investigation regarding Miss Miller that was brought by Miss Stolar?
I don't recall an investigation about that.
Great. Can you, and you're aware of what the 15807 form is?
Yes.
Okay, why do you have that knowledge?
Why do I what?
Why do you have any knowledge about a 15807 form?
Because it's a state form that we use?
Okay, do you have any training in doing that?
Yes.
Okay, have you ever completed them?
Yes.
Okay, how, in what capacity have you completed these forms?
As a supervisor?
Oh, great. Can you turn to, it'll be tab 14 in that document, please?
Right here?
Yes, please. Okay. Can you then, after the cover page, move on from that and tell us if you're able to identify this document?
Hang on 1 second here. My computer just.
I'm sorry, do you need us to wait?
Yeah, I'm sorry, which, was that your 14 or our 14?
It's your 14.
Our 14, thank you.
Begins on ERD 1396.
Thank you.
Is everybody there?
Yes.
Okay, sir,
I'm
can you,
at 1396.
I appreciate that. Sir, can you identify this document?
It's 15807.
Okay, and who's the subject of the investigation?
Alicia Miller.
Okay.
Objection, let's, okay, so, yeah. I don't think that there's been a proper foundation about this document. That's my objection.
We
Well,
just
well,
went over
we-
5 questions about how he has the basis of knowledge for 15807s.
A 15807, which could be a blank 15807.
Yeah, he knows about the form, but we haven't talked about the contents of this form. So that, I mean, all you asked him is, are you aware of what a 15807 form is? Yes, it's a state form we use. He has training in it. He's completed them as a supervisor. And now you're asking him to look at a form that's completed that I'm looking at 1398, which is the first page of this exhibit, who the subject is, who's being interviewed, and all of this has to do with a subject of an investigation that this tribunal has already said is not part of the issues for this hearing. This was part of the issues and the complaints regarding the probable cause hearing. However, if one were to look at page 1409, which is also part of that exhibit, I could see where somebody might want to use this for the purposes of impeachment.
Excuse me, sir, can you not turn the page? There was not an instruction for him to. I'm trying to conduct an examination here, Judge, and I don't. I mean, really.
Okay, you asked him to look at tab 14.
Right. At the first page, and I asked him who the subject, and we didn't even get past who the subject was. We had interference on that question, and then we had a colloquy on that question. We haven't had an answer yet, and then you invited him to go look at another page.
I didn't invite him to look at anything. There was an objection as to the relevance of this because this is on a topic that we have already decided, I have decided, is not bounds for this. Purposes of this hearing was this investigation. Now, if you would like to make the argument as to another page in that may be used for a different purpose, you may make that argument, sir.
Judge, I understand what you're saying and what you just said. All I want to be clear for the record is that the only question that's standing is who is the subject of this investigation. And if you're going to rule that that's irrelevant, I can't ask that question on its face, then I'd like that ruling, please.
For the purposes of this hearing, we have already determined that as any issues pertain to the allegations in the original complaint that are outside, let me go back to the complaint. Outside paragraphs that pertain to paragraphs 3 through 10 are out of bounds. We may only address paragraphs 11 through 24. 25 through 32 are also out of bounds. So, if all we're doing is asking a question as to what name is in what line, you can ask that question, but we're not going to get into any discussions into the actual investigation itself for the purposes of trying to bring up any of those claims that we just said were out of bounds.
Did anybody say anything like that?
Their objection is that this was something that was out of bounds because we had already decided that. So I have to address the objection that's been made. Whether you agree with the objection or don't agree with the objection, I need to put my ruling on the record. Now, might this exhibit on perhaps other pages be used for another purpose than addressing claims that are out of bounds? That has yet to be ruled on.
Great. Can I continue with my cross-examination, please?
Sure.
Thank you. So, sir, can you answer the question?
I don't know what the question
The question is, who is the subject of this this 15807 in front of you?
I'm sorry, but I want to object. It's the same exact question. So it'd be the same basis for objection. And furthermore, if this is being used for purposes of impeachment, I don't think that that has been properly set up to know whether or not he remembers participating in this or not.
We haven't gotten there. The only question he's asking is, sir, can you read on the first line of this form that you say you fill out, you've had training on, you use them in the course of your employment. Who is the subject of this investigation as you look at this form 15807? And I'm going to allow just that question.
Alicia Miller.
Okay.
Great. And how do you have a basis to form that conclusion, sir?
It's right in front of me.
Okay, but is your do you have some training that identifies that, or are you just reading the words off the page?
I mean, training. The line says subject to the investigation. That was a question, and he has her name on it.
Great. Okay. And you don't recall participating in this investigation at all, right?
No.
Okay. Can you please turn to the 17th page of that exhibit?
What page is that on top?
That's the 17th page. I don't know what else to say.
On the top.
I don't have a number on the top.
Would it say 1412 on the top?
This is a 15807B.
Looks like it's a chronological log. Is that what we're looking at?
Yes.
Thank you.
And so you know what a chronological log is?
Yes.
Okay, and you have training in that, right?
Yeah.
Okay. And so I see here on 2/21 of 2020, it reads, sent investigatory notice via email to Theander. Do you see that?
Objection. Can we, this, okay. I think that this is not his document. And I think that the questions are argumentative.
I don't know how I can impeach somebody when I am constantly being interrupted and said that it's those aren't even serious objections, Judge.
Well, that may be your opinion, whether they're serious or not serious objections.
Mm-hmm.
But everyone has the right to make objections. And
Just like
They just
everybody has
do.
the right to call the police, right?
Are we really gonna go there, Attorney Hitchcock? Is that necessary? I mean,
Well, yeah, I'm
I mean-
sitting here traumatized being in this room after they called the police and the state power was used against me. And yeah, I do think it's relevant. I do.
okay.
I do think we're going there. You know, with the secret button, panic button that nobody told us about, you know, the constant reference to YouTube. I think these things are relevant, Judge.
Okay, all right. Well, the question is, do you see there's a line here dated 2/20/20 that it says, sent investigatory notice via email to Theander, set for 2/24 at noon. He asked you, do you see that?
Yep, yes.
Great. And I also see at 2/24/20, it says interviewed Theander at 2 p.m. per his request to move back the appointment. Do you see that?
Yeah.
Okay. And then on 3/2/2020, it says review video from recorded of the entrance to the satellite office at the start of first shift on 1/16/20, along with Captain Theander. Do you see that there?
Yeah.
Oh, okay. Now, I'm going to ask you to turn, and just remind me, you told us that you didn't hear any rumors about Stolar, right?
I didn't recall any.
You don't recall any. Okay. And you didn't recall, also you testified under oath today, that you didn't recall hearing any document or any rumors about the fishing trip, right?
If I don't testify about rumors, I'll talk about something that was true.
I didn't understand that, sir. What does that
I
mean?
said we heard rumors about a ton of stuff.
Okay. The question that I'm asking you specifically now under oath is, are you staying here that you know of no rumors about what happened at the fishing trip? Is that what you're telling us?
I heard rumors about the fishing trip. I heard rumors about a lot of things.
Okay, what did you hear about the fishing
I
trip?
don't remember what was talked about.
Okay. And that's your testimony under oath?
Yeah, I wasn't there.
Okay. And so I want to be clear. You never heard any rumor of any kind that Toutant sexually assaulted Joanna Stolar at the fishing trip. Is that true?
Objection. He's already asked and answered it. And this is just argumentative with him.
That specific question has not been asked, but he has already stated he didn't go to the fishing trip. He heard rumors, but he doesn't recall the specifics of any rumors he heard. So I'm going to allow the question because it's a specific question. Did you hear rumors of the fishing trip in regards to Mr. Toutant and Miss Stolar?
It was 5 years ago. I probably did. Do you recall anything? No.
And do you recall watching the video in regard to the Miller investigation as identified in that log there?
No.
Objection
No.
relevance.
Sorry.
Question's been asked, he's already answered it. I'm not going to draw it back. The answer was no.
I'm going to ask you to turn to the 18th page of that exhibit. And for the record, this is a 15807A. Do you know what a 15807A is?
Mm-hmm.
What is it?
That form.
Okay, what's the purpose of this form?
Investigation.
Okay, does it start an investigation, do something else?
I'm going to object. This is, you're asking him about a form and the specifics in the form. And it's not even established whether or not he filled out the form.
And, well, I'm still trying to figure out what page he's on. Because I'm looking at Bates numbers. And these pages are not chronological, one of whatever, like the other ones were. So I don't even know what page we're on.
They are numbered at the bottom, like page
Yeah, but I've got page 5, page 6.
Okay.
Is it,
This is page 18.
Okay, thank you. Let me at least get to there so I'm on the same
bottom.
page with everybody else.
that's the number at the bottom, right?
All right.
I'm sorry, I just want to clarify.
It's the number on the bottom is what I'm finding, and that would be ERD 1430 because the top of it actually has an A by the 15807.
And did you say 1413?
Yes.
Okay.
Do you see yourself on the list of potential witnesses?
Objection relevance, that's completely irrelevant.
I'm not sure where we're going
I'm
with
just
this.
impeaching him. That's what's happening. He said one thing. I'm confronting him with the facts that say something else. That's what's happening here, Judge.
Well, I understand that,
Okay.
but impeachment deals with I've said something and now I'm saying just the opposite. Nowhere have I heard in anything he has said thus far, apples are orange and now apples are blue. What I have heard and what I have heard through the bulk of testimony in the last 5 days has been, I don't recall, I don't remember, I may have, with a majority of the witnesses. So the fact that he doesn't recall something and now you're asking him to look at something is not impeachment. Perhaps we should be refreshing his recollection rather than trying to use this for an impeachment because he's not disagreeing. You either remember or you don't. This isn't like he's saying, it never happened, I never did any of these things. His answers have been, I don't remember. So I don't think this is a proper impeachment. I think you probably could refresh his recollection and then ask him some questions, and if he disagrees, then you have something to impeach on. But this is more of a refreshing recollection issue as opposed to an impeachment because he still doesn't recall anything. I haven't heard anything yet that is in complete contradiction to what his testimony was on direct.
I think we've got an evidentiary issue in that I think him saying that he doesn't recall and then we present evidence that makes it more or less likely that he should recall is impeaching him. And if I think that those other statements are not reflective, I think, on what the law is. So that's my concern with that.
I disagree wholeheartedly with that assessment as to what is proper impeachment and what one needs to refresh one's recollection. Not remembering is not something you either remember or you don't. And a majority of the witnesses in this case cannot remember things that happened 4 years ago. And many times documents have been used to refresh recollection. People have attempted to refresh recollection unsuccessfully, and that was the end of that. But you're welcome to try and refresh his recollection, but I don't think any groundwork's been laid thus far for impeaching anybody when we don't have a prior inconsistent statement that he has made here in court versus what he made there or at this tribunal. So I disagree with that assessment and analysis.
Great. Okay. Do you recall hearing making? Let's put it another way. I understood you to say that you were not aware of Joanna Stolar making any complaints about rumors to you. Is that a true statement?
I don't remember her making any complaints to me now.
Okay. Is it possible that she did, or is it not possible?
Objection. I don't think he's going to be able to answer that. That's.
I think he can, and I'm going to overrule that objection. He either knows or he doesn't. It is speculative, but I'm going to allow it
Nick, I think it did say before, when she had asked him, did she complain about things to me while she had worked? Probably, and I think I admitted to saying yes, she probably did. What, remember that they were 5 years ago? I have no idea.
Okay. And is there anything that she could have complained to you about that would have, you would have had to file a 15807A or caused her to file a 15807A?
I don't know what would, no, wait to answer that.
Objection, I think it's too vague.
Could you clarify the question, please?
Do you not understand the question?
Could you just maybe,
That wasn't the question.
yeah.
My question to you now is, did you understand my last question?
No,
Okay, what about it didn't you understand?
Could we just,
all of it.
Okay, there's nothing in particular that stood out to
I don't know how to
you?
answer it, so.
Okay. Was there ever a time that you knew when to answer it?
objection, this is just arguing.
I'm gonna sustain that. Just, if you could please, sir, clarify your question.
Do you know who Eric Belling is?
Yes,
Okay. Now, who is Eric Belling?
who's an officer?
Okay. Do you know him to be a liar?
Objection, what's the basis?
Yeah, I'm
Well, either he knows or he doesn't know. And then he could answer that question on that basis. I don't know what the, I don't even know what the objection is.
You're asking one witness to testify as to the credibility of another person. You can ask him if he has an opinion as to that, but to just say, do you know him to be one? Why don't you just ask him?
I guess that's another way of asking the same question. Do you have an opinion on whether or not he tells the truth?
I have no idea if he does or not.
Okay. But you worked with him, is that right?
He was an officer when I was there.
Okay. And it's your testimony here today that the officers under your, was he ever under your supervision?
My direct supervision. You probably don't understand how correction works, but that's a difficult way to answer it. To some extent, yes, if he's working on the shift I'm working. Was I his direct supervisor? No.
Okay. So my question to you that was objected to before was, if somebody makes us a comment to you or it brings anything to you on any matter, the question is, are there some matters that you are required by your position to start a 15807A or instruct that person to start a 15807A?
I can't instruct an officer to start a 1507A because they can't.
Okay.
Based on my experience and my knowledge, there are some things that are brought to my attention that I feel it's necessary to start a 1507 or start an investigation on. Correct.
Is that your personal policy?
I don't have a personal policy.
Was that the DOC's policy?
Was what the DOC's policy?
What your answer, and correct me if I'm wrong, we got down to there are some things that would cause you to file a 15807A if you learned about it, right?
Correct.
Okay. Are you doing that for fun or are you doing that for some other reason?
Objection, that's really argumentative.
It is argumentative. If we could just ask him, what is the purpose?
What is the purpose of it then? Why do you do this? Why do you... What's the objection?
You said, why do we do this? I don't know.
Well,
It's
we're
very
referring
vague.
to the 15807A, okay? You've testified, sir, that there's sometimes things come up that require you to fill out this 15807A.
Correct.
Okay. Now the next question, and you said yes. The next question is it something that you do on your own, or is there a policy or some other directive that causes this next action?
There's training that we went through to be able to do what supervisors go through, investigations training.
And you know what be aware of means? Made aware of, I'm sorry.
I guess it depends on the context that you use it in.
Okay, how about in the DOC, what does that mean?
That's vague. Objection.
There's no definition to that in the DOC.
You don't, you don't, there's no set of circumstances in which you would become made aware of that would cause you to have to act. Is that true?
That's not what you asked me.
Great. Can you answer the question that I just asked you now?
Can you say it again?
There are no set of circumstances that would cause you to, that you were made aware of that would cause you to act, for example, by filling out a 15807A.
No, that's not true.
Okay. Will you look to page 35 of the exhibit in front of you? What do you think this document is?
Objection, I don't, can I just get to the document? My computer locked up. And what was the page number again?
35.
Sorry, it's. Oops. Oops.
Can you identify the document, please?
It's a 15807C.
Okay, and who's being interviewed in this document?
I'm gonna object. You're asking him hearsay questions about a document he didn't write about another person. He's not involved in this document. Hearsay upon hearsay. He wasn't the investigator.
I understand that he's not asking for the truth of the matter asserted. What he's asking is, do you see this document? What kind of a document is it? He's testified that it's a 15807C. And now he's asking, do you see in the block name of, who did you ask? Was it investigator?
I just, yeah, but who's the person being interviewed?
Oh, okay. Why don't you just say, can you find the interview block?
Yeah.
Do you see a name typed in there? What is the name in that block, sir?
Objection.
I don't.
Well,
I mean,
but so
you
it's
can
not
do
that easy to get right. But when somebody makes an objection and then they say, "Oh, it's hearsay upon hearsay," it's not that easy to get the question out.
Well, nobody understands the purpose for what you're doing.
I think that's okay. I think
part of the
that's
thing.
okay that they don't need to understand. He can just simply answer the question without them making an objection that they don't know what it is, that it's double hearsay. Again, that response there makes me think that you also believe that these are not ingenuous objections here.
Well, don't speak for what's in my head, sir.
No, I only speak for what you said, Judge. That's what I said.
Okay. Well, you're wrong. This document is hearsay within hearsay. However, if we're just asking about a form and a contents of the block, and it's not being assertive for the truth of the matter asserted, it's just that's what the block says, I will allow the question. And he has answered it.
But even if it was hearsay, it would have to be admitted anyway.
And none of this has been asked to be admitted, so please.
Okay.
Please answer that question.
Great. I'm glad that we got that foundation down there. So if you look at page 37, which is the next page over, sir, at the bottom there, I believe it's the second penultimate paragraph. Do you see that there?
Mm-hmm.
Okay. And then at the bottom, there's a couple of KS's and EB's. Do you see that?
Yep.
Okay. And EB says, the question there is, do you think that Lieutenant Miller behaves in ways that are abuse of her power over staff? And EB says, I do. Like the chart. Stolar talked to Captain Theander about it, and he said, We can't do stuff like that and keep that in mind. Miller then went over Theander's head and later told us she is taking it to Greff. Okay? Now, my first question, do you see that there?
Yeah.
Okay. Do you know who Greff is?
Yes.
Who's Greff?
Our security director.
Okay. At this time, was Greff above Captain Theander? I guess that's you?
Yeah.
And how about Lieutenant Miller?
Yes.
Okay. And in the progression, if Lieutenant Miller were to jump over you, she would be going to Mr. Greff. Is that fair?
Objection, why are we getting into the Miller facts? Where is
We're
this
not
going?
getting into the Miller facts because so far he's asked, is that what that says? Now he's asking the order of rank of people. Again, none of this has been asked to be marked, offered, exhibits, any of that, and I don't have proper foundation to have admitted this for anything because at this point, I don't even know who this KSEB whatever it is, so I'm going to allow his question as to rank and who's above who. So could you please answer his question about who reports to whom? If you can, sir.
Yeah. I mean, there's rank, obviously. We follow that, but there's also numerous times that a lieutenant won't talk to their shift captain and will go straight to the security director if they weren't necessary. That's not necessarily jumping above my head.
Okay.
There's things I'll talk directly to the warden about and not possibly go past the security director, not to jump past them. That's just how open communication works.
Great, thank you. Judge, it's my understanding that R14 is already in the record. Is that a misunderstanding?
Let me see. That would begin on 1396. And no, it is not.
Okay.
Nothing in that entire packet is in the record.
All right. So, do you deny that you told Stolar that we can't do stuff like that and keep that in mind?
I don't recall that conversation.
Which page are we on
Yeah.
again?
What page?
We're not on the page. Do you deny that Lieutenant Miller went over your head about the Stolar complaints to Greff?
Objection, you're asking him questions specifically about the facts in this to try and impeach him, but we haven't even established whether or not he remembers anything about the interview. And you're asking questions from another person's interview in its specific questions.
See, now this is just
Again.
coaching, Judge.
I'm not coaching anybody.
Okay. She's made her objection,
Right?
and that you are asking about facts that pertain to somebody else's interview. This is how. I don't even know whether he's ever seen somebody else's interview, whether you're privy to see the interviews of other people, and whether people may or may not have said. But we're talking about the Miller situation, and that's out of bounds. I've given you significant leeway to use the Miller packet in terms of asking him questions about a form that he trains on, that he's had training on, that he does fill out. But as to that question, I am going to sustain the objection.
I've never conducted a cross-examination like this before in my life. I don't think I've even asked 3 questions. And let's recall, Judge, that when you stated that you knew all about Brown and Roberge and Fauertech and letting everything in on the record, you said that on Wednesday. and then you came in, or maybe it was Tuesday, then you came in the next day when they were putting on their case, and the rule for everything that we did yesterday was on the instructions of Lurk, on the completeness of the record, I'm going to allow it. I'll give it whatever weight I think it deserves, but I'm going to allow it. And on that basis, we were able to go forward, I thought, on a not only professional basis, but on the basis as commanded by Lurk. And now, once again, when it's my time to ask the questions, and the complainant's trying to get evidence in, then there's restrictions, and we seem to forget about Roberge, we seem to forget about Bowen and Brown, and you had that great quote, Judge, and I seem to forget it now, but it's not heavy-handed restrictions on evidence, but that goes in parcel with that. But that's ultimately what we're talking about here. As you know, and as we talked about before, and you've just said several times that things weren't relevant, and as you found your own self when it was their turn, that relevance isn't a bar to presenting evidence here, but it seems like for me it is. And I'm making two objections. A, you know better, and B, that there's one rule for the complainant and another rule for the respondent, and on what you've just done now, based again on your saying that you've read Brown, you've read these cases, you know them, and your stated behavior on yesterday, where you allowed them to bring absolutely everything in the kitchen sink in, this here is one rule for them and another rule for us, and you should recuse yourself on that basis, because there are facts on the record that show that you are wedded to a conclusion here. And in this case, it's the exclusion of bad facts for the Department of Corrections.
Okay. Well, I've heard, excuse me, does anyone over on the respondent side have something they want to say in addition to this, just to this objection?
I just wanted to point out that yesterday the complainant rested.
Okay, yeah. The complainant did rest yesterday, and a lot of exhibits were admitted, and they were, majority of them were admitted without objection or based on a standing objection, and we were actually looking at exhibits in terms of evidence and that sort of thing. The parties were well aware. They had an opportunity to provide me with what they felt was at issue for this hearing. The Miller portion of this case is not at issue for this. All I'm doing is responding to objections. Any attorney or an individual that's pro se can raise an objection to a question that's being asked by counsel. That's the way it works. Somebody asks a question, sometimes there's no objections, and other times there are objections. I have to hear that objection, and I have to make a rule. What I have said that is not relevant for the purposes of this merits hearing are the things that pertain to the complaint that involve complaint allegations or claims numbered 3 through 10, as well as 25 through 32. To get into what happened with any complaint regarding Lieutenant Miller is out of bounds. I allowed questions pertaining to the form that was being used. But counsel knows better than to get into the facts or ask somebody about the facts of the Miller case. That has nothing to do with this issue that is before this tribunal. We're dealing with the sexual assault that happened with Miss Stolar. That is the only issue. So those are my rulings, and you may disagree with my rulings. You have every right under the sun to disagree with anything I say, but it doesn't mean you get to keep, my rulings are my rulings. and then we move on from my rulings to continue with the case. That's how this works. Please don't. Okay? You always have the opportunity to appeal anything I've done. And, you know, I love how you refer to New Rock, you know, with the phrase, you're, you know, psychologically wedded. I know where that comes from. I know the New Rock, you know, case. I mean, it's a very old nursing home case, but it's got some great language that pops up that you can use. I get it. I'm not psychologically wedded to anything, despite what you may think, and you're entitled to your beliefs. The only thing I'm psychologically wedded to is the fact that the complainant has a right to tell her story. The complainant has a due process right to have a hearing based on evidence. She's had that right. That is what I've been begging, pleading, ordering the parties to do from day one, is focus on the issue that is before this tribunal. Unfortunately, everybody, both sides, have wanted to bring in everything else in the kitchen sink into this. And it's like, you know, trying to rein people in to focus on the one thing. I've already explained what impeachment is. I've explained refreshing recollection. Went into a great deal on that yesterday. What we're trying to do now, in terms of getting into the facts and, you know, didn't you do on an investigation that is not even the subject of this hearing, that is not even supposed to be part and parcel of this hearing. That is out of bounds. And because it's already been dismissed, and Lurk will take that portion up on appeal when this case is done. This portion is. And they'll make a decision as to that. And if that gets reversed, guess what? Now you can come back and use everything you wanted to use, because those are the portions of the complaint that will then move forward. But for me, it's not part of what I'm here to hear. I'm not authorized to hear anything that's not before me. I just can't. So that's why I wanted clarification from everybody before we got started on this. Because I know what I can see in this complaint. I know what I can see in the initial determination. And the stuff that people want to bring in has no bearing on what is before me. I've made my ruling. I realize you object. I realize you're asking once again for me to recuse. It's not going to happen. Okay? At some point in time, Lurk will make the decision that I messed up, or I didn't mess up, I should have recused, or this or that. But until that time comes, no matter how many times you ask me, I'm not going to recuse. I think I've been very clear on that. And I'm not hearing anything new that would rise to that level. Okay? So I'm asking that if you have any actual questions other than the Miller case to ask Captain Theander, please, sir, continue.
All right, and just to be clear, can you put on the record that you're finding that you're not allowing me to discuss this because it's irrelevant? Can we get that clear?
I'm not allowing you to discuss it because it's not an issue that is before this tribunal.
That sounds like relevancy to me.
You can define it any way you want. I've put my answer on the record, and that's all you're going to get from me. Could you please ask Captain Theander another question?
I'm going to feed my meter.
Are you asking to take a break?
Yes.
How long do you need, sir?
5 minutes.
5 minutes.
Judge, you off the record?
All right, we are back on the record in the matter of Joanna Stolar versus Wisconsin, State of Wisconsin Department of Corrections. I do not know why I'm having difficulty with that entire name, but it seems that I do it every time. My apologies to everyone. Case number is CR 2020 02513. appearances are the same. We last left off with cross-examination, still ongoing, of Captain Theander, Attorney Cross, Hitchcock Cross.
Thank you
Excuse
so
me.
much. I just need to put on the record, I went outside just briefly here to put change in, whatever the amount or equivalent of change, feed the meter is. And when I came back into the building, I was approached by a Mr. Officer Andrew Hyatt here of the Capitol Police. He, in conjunction with Tina, he gave me instruction here saying that I had admitted to roaming the buildings. I had no concept of what he was talking about. He then gave me a restricted area of this building to go into. I understand that they have now put up a sign that says this is a staff area only. That sign has not been up. I have witnessed that sign being faced towards the wall, and the officer showed me that the sign had been moved from where it had been located to another area in front of the elevator. He then read to me from an administrative regulation in which he proposed that it was, contrary to rule for people, the public, to go into closed offices or in unauthorized areas. I showed him my identification badge and explained to him that I did not see nor was made aware of any sign or other indication that any areas of this building were off limits to anybody. We can tell then there that this is a sign that they have just put up, which is what the officer explained to me, that he just put up the sign there and restricted my access. Part of the problem, again, with this hearing is because there is a limited area, we are frequently, and there has been occurrence of this happening before, when the complainant and the respondent are in such proximity. The complainant herself, for example, has overheard statements from the respondent's attorneys. One of the reasons why I went and walked elsewhere at that time was to put some distance between us. I feel that both the attitude of the officer, and I also will be clear that the officer said that the rules applied to the respondent, but made it clear that he had not communicated that message to the respondents. I still do not believe that has happened yet. And I think, again, here, we have more evidence on the record of the state of Wisconsin using its power here, both in this building to intimidate the complainant. And again, I raised the issue of YouTube and that fact here. If it wasn't for the fact that I have this recording of Rusty and the officer and myself talking about how many open buildings there are, and this is the statement that the officer is referring to when he says I admitted to roaming the buildings. I have knowledge that there were several vacant conference rooms in this building here that is apparent to anybody with eyes. Rusty, of course, was saying that they were not fitted for the purpose, which of course then meant that there was a secret panic button that the parties, or at least the complainant, was not aware of. So again, I need to make both the record and LERC and the tribunal aware of what I feel is intimidation of the complainant here by the state of Wisconsin in the person of this officer, Andrew Wyatt. I also believe, frankly, that this is a violation of both my and my client's First Amendment rights, particularly when the issue of YouTube was the primary concern of Rusty, and I will also put on the record that I observed this officer going through his phone while we were going through the hearing so far. It's my belief that he was looking for the administrative code that he referenced to me. Now, again, I have no problem not going into people's offices because I haven't gone into anybody's office, and I have no problem going into any non-restricted area when it's so indicated. But I want to be clear for the record that at no time in this building was there any indication that any area that I was in was off limits to the public. There was no sign, and the fact that they have now put up such a sign furthermore indicates that fact. So I will be, of course, including the video of my conversation with the officer, Andrew Hyatt, as well as the recording with Rusty going on about the YouTube in the Wii box, and make that part of the record here in this case. So that's what I need to put on the record, Judge. Thank you.
Okay. Is your Wii box still open?
I hope so.
It was sent to you yesterday.
Yesterday. I think I got
I think-
48 good hours, right?
I don't know. It's a time. I've heard 48. I've heard 72. I don't know how they work. I've never requested one for myself, obviously. So in that email, it will tell you. If you find that time limit has run out, you're going to have to notify me again so that I could request another one for uploading.
Thank you.
That's just giving you a heads up.
Yeah,
I don't
Ms.
know.
McElroy doesn't like direct communications very much.
I don't know who any of these people are. Again, I stay in my lane. I know who I need to talk to for my job and who my cases are. That's it.
Right, I
I
understand.
don't, I just stay in my lane. I find life works a whole lot easier that way. I cannot speak as to anything that you've just put on the record because you're just telling me these things. So I don't know what has or has not occurred, nor am I going to interject as to what has or what has not occurred in terms of what you just told me. I've been sitting in this room. Okay? So it's on the record, and I guess I don't know. Did the respondent wish to say anything in terms of Officer Hyatt giving you guys the exact same restrictions that nobody's ever, that just basically stay wherever it is? I don't know.
It's the Administrative Wisconsin Admin Code, ADM 2.14 sub 2. In order to preserve the order that is necessary for the enjoyment of freedom by occupants of and visitors to the building and facilities, and in order to prevent activities that physically obstruct access to department lands and buildings, or prevent the state from carrying on its instructional, research, public service, or administrative functions, and pursuant to section 16846 stats, whoever does anything or any of the following shall be subject to a forfeiture of not more than $500. Just a sec.
What code is this?
Oh, it's the Wisconsin Administrative Code, ADM, pertaining to Department of Administration.
Okay.
2.14 sub 2. And then we have sub D, says without authorization enters private offices or non-public areas in those buildings and facilities managed or leased by the department.
Okay. Were you just looking this up as Attorney Hitchcock Cross was speaking?
I just Googled it right now and
Oh.
I got to.
Okay.
I took a guess that it would be under the administrative code.
Well,
and
I
so-
can tell you that's a statute I have not read. So now I'm curious because I love to find new statutes. But in any event, so other than, what else do you have to say if you have anything? You don't have to say anything, but I always give you everybody the opportunity.
Oh, okay. I guess, the DOC attorneys have not been roaming the hallways in the prohibited areas or entering anybody's offices.
Okay.
So I guess it's self-evident
Okay.
that you can't be going into people's offices or non-public areas. We do have an old case that's similar. It's State versus Elson. It's a Wisconsin Supreme Court case. It's 208 Northwest 2nd, 636, 60 West 2nd, 54, again, 1973. And it wasn't a trespassing case, but it has some elements that are akin to this. And this involved an attorney who refused to leave a ward in a mental hospital until he'd seen a client. But this was after he had made some statements in the presence of other patients that had caused him to become agitated, and he was properly convicted of disorderly conduct. So the fact that this building is owned or leased by the state of Wisconsin does not give anybody carte blanche to go into offices or roam the hallways or do anything like that.
Okay, all right, thanks. Everybody's put something on the record. That's it. I only know where ERD workstations are, where they've given me a workspace back over here, and you have to have a badge to get in, and nobody's supposed to come in there but ERD people. So that's it. That's all I know. Okay, all right. Can we continue with cross-examination, please, of Captain Theander?
No more questions.
All right. No further cross. Do we have any redirect?
No, thank you.
Okay. All right. Captain Theander, thank you for your visit.
Thank you, guys. Pleasure to be here.
All right. You are free to go. All right. Hold on, Attorney Cross. We're not done. He can go.
Then we're getting another witness here?
I don't know what we're going to do yet, but I'd like to speak with everybody.
Right.
So, Attorney Cross. Oh. Okay. All right. It's 12 o'clock. We've only managed to go through one witness. 5 o'clock is the end of the day. I'm not asking you to rush. You have all the time that you need for this, but I need to get an idea of about how many more witnesses do you plan on calling today, and what is our next one? Do we have one lined up? Do people want to take a short lunch? I think we've had numerous breaks. I don't know if people need bathroom breaks. I don't know how long you feed the meter for. I don't know how that
we
works.
just fed it. I'd like to go for at least till 12:30.
Okay. Is there somebody we can call now?
Yeah, I don't know if we're gonna get done, but I can call somebody.
Well, that's okay. We can stop. We can stop mid through.
Great.
Okay.
I'm
So
ready. Let me see
so
when you're
who do we know who it's going to be?
Mackenzie Roberts.
Mackenzie Roberts. All right. Let me find that name. Witness list. So I can spell it right, since I have mangled everybody's names. There we go. Mackenzie Roberts. Okay.
Do you bring lunch? What's your lunch story?
If I remember, it depends on what my sugar's at.
Yeah.
If my sugar's low and dropping, then obviously I need to eat something, but I have to limit the carbs because then it spikes it. So, like today,
How does the management work with the workaholism? I think this seems to be completely out of
I have a continuous monitor,
Oh.
so
Okay.
I eat a variety of little snacks throughout the day, and then like this, because I can't eat a whole lot of food. So this gives me nuts,
Okay.
dried fruit,
Yeah.
and some pepper jack cheese. So it kind of gives me a little bit of everything, but the carbs, they're listed on the inside. That's what I primarily have to watch. I try not to have more than 50 to 20 carbs at any meal. 15 to
How do you
20.
put the unit there?
It's just, I'm not counting calories.
Right.
I mean, I'm not doing the math. So that's kind of how I roll with that. But, obviously every now and then. Is it, nobody will take it?
I'm recording them up here.
Okay. Nobody's gonna get your phone, right?
Oh, better not. I better start across.
Look, I'm just asking.
Well, with the cop right there? I know, he's got his eye focused on you two, but maybe we could take it off for the phone for
Okay.
a minute.
You must be Mackenzie Roberts.
Yes.
Hi.
Hello.
Welcome, Miss Roberts. Okay. If you could raise your right hand, please. Do you affirm or swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You may lower your hand. I'm going to give you a bunch of things that sometimes I've forgotten to do, and then I have to interrupt people. Okay. First, nobody wants you to guess. Okay. So you can answer. It's perfectly acceptable to say, "I don't remember. I don't recall." Okay. And then the attorneys will take it from there if there's something else they need to do. Also, if somebody asks you a question and you don't understand it, don't guess. Just tell them, I don't understand what you're asking me. And then they'll rephrase it, or they'll ask you, well, what don't you understand about it, and that kind of thing. The thing we don't want you doing is guessing or speculating, because that kind of defeats the whole purpose of this. If you ask a question and then somebody turns around and says, I object, okay, stop. Don't answer, okay? Because then I need to hear whatever the objection was from that individual, and then hear more from the person who asked the question, and then I'll make a decision, and then based on my decision, I'll tell you, yes, you can answer it or not,
Okay.
okay? Because it happens.
Sure.
Any questions about anything?
No.
All right. Attorney Zacard, is it?
Excuse me, before we can begin, can you please move over to that side here?
I have no objection, sir.
Thank you.
We have a switch of the guard, and this is
Officer John King.
Officer King. Thank you, sir. Okay. Attorney Zacard.
Thank you. Hello.
Hello.
Ms. Roberts, did you used to work for the Department of Corrections?
Yes.
Okay. When did you work for the Department of Corrections?
From May 2018 to April 2023.
Thank you. And did you resign from the Department of Corrections at that time?
Yes.
And where was your job assignment when you worked for the department?
Like what institution or
Yeah.
Dodge?
Dodge.
Correctional.
Were you at Dodge the entire time?
No. When I first started, I worked in dental, and I worked mostly at Tachita and Dodge, but I would help out occasionally at other institutions. When I was an officer, I was solely at Dodge, though.
Okay. And did you know a person by the name of Johanna Stolar?
Yes.
How did you know Ms. Stolar?
She was a coworker. She was also an officer at the time I was.
Okay. And when Ms. Stolar was at the institution working, did you work in the same unit?
She was the regular first shift officer of the unit that I had the second shift relief of.
Okay.
So there would be days where, like a couple of days a week, that I would relieve her from her post. Yes.
Okay. And so did you ever have any conversations with Ms. Stolar regarding any rumors going around the institution?
Yes.
What kinds of rumors did you have discussions with Ms. Stolar about, if you recall?
About her relationship with a supervisor.
Do you recall who that supervisor was?
Yes, Nick Farley.
And just to clarify, how did those discussions come about? Did you ask her, or did she mention it? Or something else, if you recall?
I don't recall how it originally got brought up.
And in general, did you hear rumors about other staff members while you were working at Dodge?
In like regards to her or just,
Anybody?
oh, yes.
What, if you recall, what kinds of things did you hear about generally? What kinds of topics were there?
The place is kind of a rumor mill, I guess. You spend a lot of time there, so anywhere from like job misconduct, someone didn't do something correctly, all the way to, marital situations, things like that.
Did you ever hear any rumors about yourself?
Oh, yeah.
What kinds of rumors did you hear about yourself?
When I was pregnant, people were speculating I was pregnant before I told anybody I was pregnant. People would question if you were dating somebody or things like that.
Did you, are you familiar with somebody by the name of Jason Toutant?
Yes.
How did you know Mr. Toutant?
He was also a coworker. He was a sergeant at Dodge, or is, I guess.
And, just to back up, so did you hear about some ice fishing tournament that was going on in the end of January of 2020?
Yes.
Did you attend that ice fishing event?
No.
Okay. Did you hear any rumors about things that occurred at the ice fishing event after the fact?
Yes.
What kinds of things did you hear?
That there was a lot of heavy drinking happening, and that there may have been inappropriate encounters between certain staff. Between Stolar and Toutant, specifically.
Do you remember anything else about those rumors?
I do not, just that there was some encounter alleged between the two of them.
So, did you ever talk to Ms. Stolar about that ice fishing event? How did that conversation occur, if you know?
We were working together on a unit, and she was complaining, or not complaining, she was talking about how she felt like she was being targeted by other staff members because of the situation that happened at this fishing tournament. So that's when I asked her point blank kind of what had happened.
And do you recall what she told you about it?
She just said that he was inappropriate with her, and then I didn't really go into other details.
Did she ever complain before the ice fishing incident about any inappropriate behaviors by other staff?
Not that I recall, no. Only the Farley situation.
What do you mean by the Farley situation?
She would basically, she 100% thought she was, or said she was in a relationship with him, and he is still very clearly married. And just all the details of that relationship, I guess, is what she had talked about.
And was this information you heard from Ms. Stolar?
The Farley thing?
Yes.
Yes, from her. I mean, there was rumors about it, but directly from her as well. She would talk about it.
Did you, so I'm assuming you know who Nick Farley is?
Yes,
Okay. And how did you know him?
he was my direct supervisor.
Okay. Did you ever have any conversations with him about the situation?
There were a couple of times I was working a shift with her, and he would call and ask to speak with her, but, no details with him about it.
Okay. How did you know it was him on the phone?
He would say, "Hey, it's Farley."
After that ice fishing incident, and I'm sorry if I already asked this, I didn't write it down. But, so after the ice fishing incident, did you hear any other rumors other than the information about Farley regarding Ms. Stolar, if you recall?
Just whatever the incident with her and Teuton was, that there was something inappropriate happened at this fishing tournament.
Do you know who Alexander Hartsign is?
Yes.
Did you hear any rumors regarding him and Ms. Stolar in the institution?
No.
So, do you recall, making a complaint about, a conversation with Ms. Stolar in, I believe it was August of 2020?
Yes.
Could you tell us what that, complaint was about?
That was the day that we were working together, and she was talking about how she was feeling targeted. At the time, I believe we received an email. I can't remember exactly what it was about, but basically stating there was a lot of overtime at this point, and there were people turning in doctor's notes saying they couldn't work past 8 hours. And I do know that, or I shouldn't say I know, it was rumored that Stolar was one of these individuals. And that shift we were working together, we received an email saying that if you have one of these doctor's notes that you are not fit for duty due to the fact that you have to be able to work overtime. And that's what kind of got her saying that she felt that this email was a target towards her. And she stated something along, obviously I don't remember the exact wording, but that she has enough to take down blow up the institution, and that she knows how she can do so.
So, did she say anything else in addition to that?
She mentioned about Teuton, how she knows how she can play this situation to her advantage.
Now, is this information that you heard directly from Ms. Stolar?
Yes.
And what, if anything, did you do after that conversation?
I was talking to my sergeant about it. I'm time, I can't remember who that was, but they contacted the supervisor that was on. I'm not sure if he was a captain at the time or a lieutenant, but he's a supervisor, Brandon Mason. And then I was called up for an interview, all during the same shift.
Do you recall who you met with?
After Mason was who I talked with.
Okay.
I'm sorry, what was the name?
Mason, Brandon Mason. I don't know if he's a captain now, but I don't know if he was a lieutenant at the time.
Just got it. So, after you did this interview, do you know what happened after that?
It was, I don't know where it went after that. I know it was not very long until she walked out of the institution and quit, or I don't know if she quit or if there was something going on. I don't know, but I know she left during her shift, and she didn't come back to work.
So, just to kind of go back here just for a second, you said that she mentioned things about Teutons. What, did she say anything else regarding him, or any details, if you recall?
The only thing was when she had told me that she knew how to make the situation with him, can blow up the institution with whatever information she had with him.
Do you know what was meant by blow up?
No, I was asked that, I remember, in the interview. Because they asked me if she meant literally, and no, I do not think she meant literally.
You mentioned that she felt targeted about the information about the working past 8 hours. So you said there was an email. Did you actually see the email?
It was an email sent to the whole institution, basically. So at the time, I know like I said, there was a lot of overtime. It was right during COVID. We didn't have a lot of staff. And people were getting burnt out, and people were getting doctor's notes to make it so they couldn't work more than 40 hours in a week or more than 8 hours, however it was worded. And we received an email saying that you are not considered fit for duty since it's part of the job description that you have to be able to work overtime.
So you did, so you recall meeting and providing the information. Do you recall whether or not, could you describe what you were told, if anything, when you met with the person who interviewed you back in August of 2020 about this incident? And
Sorry. Yeah, can you?
Yes, I'm sorry. So you said that you met with, I believe it was Lieutenant Mason. So did they explain to you what they were going to do with the information?
No, I don't believe so.
Okay. Did they show you anything to review?
No.
Okay. Do you know if they wrote up a written report?
I know he was typing. I would assume I was offered like a witness or personal, I believe that's what they're called, a personal rep, or there's a name, but, and I did have one. So I was under the impression that it was, you know, like a recorded interview.
Do you recall, is what you've described here today the same as what you reported, like?
I'm sure it was in better detail back then, since it was the same day that everything was told, but yes.
Okay. So if I were to show you a document, would you be able to take a look at and see if it appears to be consistent with what you had reported that day?
Mm-hmm.
Okay. All right, let me find it here. Sorry, I don't have it.
Are we still talking about the Foley, or are we talking about the Stolar interview?
It is actually R16.
Okay, got it. Let me see if that's already been marked. Attorney Hitchcock Cross, if you're looking at it, it's 16, and the Bates number is 1437. I'm not sure if that's already been marked, but I'm looking to see. 1437. It has not. I'm gonna mark that as respondents 55. CRD 1437. It looks like this is the investigative interview. Let me see how many pages it is. I think it says 1 of 3, but that never means anything. Okay, it is it is 1 of 3. So it's from 1437 to 1439. And I'm going to label this as investigative interview of Mackenzie Roberts. And let me put a date by it, since sometimes people have done more than one. This was from August 14 of 20. It's been marked. It's been offered. Attorney Hitchcock Cross, have you had a chance to locate that,
No,
sir?
I did not look at it, but no objection.
Okay. It's going to be admitted without objection. Okay.
Thank you. And before you have it open that, I just wanted to ask you, were there some conversations between you and Ms. Stolar about accessing Facebook?
Mm-hmm.
What was that about?
That was about Farley. She had asked if I had Farley or his wife on Facebook. I said I had Farley as a friend on Facebook. And she asked if she could use my phone after work to look, because he had her blocked. And he had been telling her, I guess, that he wasn't with his wife, and there were things on Facebook that very clearly showed that he was still with his wife.
Did you let her look at your phone?
No.
All right, I'm gonna ask you to open up this book, and it's, there's a tab for 16.
Mm-hmm.
Have you seen one of these documents before?
Yes.
What is it?
An investigation interview, basically word for word what was stated by everybody.
Okay. And who is this interview with?
Captain Mason.
Okay. And who was he interviewing?
Myself.
I would just ask you to take a look through these pages and see if this document accurately depicts what your recollection is of the interview. And just let us know when you finish reviewing it. Based upon your review of that document, does that accurately reflect what you recall in terms of the interview?
There were definitely some things that I had forgotten, but reading them, I do remember talking with her about them, yes.
And can I just ask you to look at page 1 of that document? So it's ERD 1437. So could you look in, it's about the middle of the form where a box is checked. And it says for witness interviews, begin the meeting by reviewing the following. And then it has some things that it looks like they're supposed to inform you about. Do you recall whether or not you were informed of those things?
I don't explicitly remember them being said. I'm sure that they were. I've had a couple of these and they've always been stated.
Okay. Is it your understanding that when you are participating in an investigatory interview that you need to provide as much information as you can and completely answer the questions?
Is that my knowledge? Yes.
Okay. So would you consider yourself a friend of Ms. Stolar's or more of a coworker?
I would not consider her a friend. We had worked together and would talk while working in unit together, but you know, we never hung out outside of work or anything like that. I didn't have her phone number, so I wouldn't consider her a friend.
I don't have any further questions.
I could eat. I could go eat. And
What would you like?
given what happened before, I think we should eat first.
I'm sorry.
I think we should eat first.
So you want to take lunch and then come back and
Right.
finish with Cross?
Right.
Anybody hearing any objection? Nope. Well, I believe that's what we're going to do. Let's figure out how long we're taking for lunch. It is now 12:30. We did 45 minutes yesterday. Is that about right?
I could do less today, but whatever.
What would the parties like? Doesn't matter to me.
Let's do 30 minutes then.
30?
Yeah.
Okay, it's almost 12:40, so we're going to go from 12:40 to 1:10, okay? Thank you, everyone.
Thank you.
Okay, thank you, everyone. We are back on the record in the matter of Joanna Stolar versus State of Wisconsin Department of Corrections, CR 2020 02513. Appearances are the same. Ms. Roberts is still under oath, and we were just beginning and had yet to start with a cross-examination by Attorney Hitchcock Cross, your witness, sir.
Did you file a complaint against Lieutenant Farley?
The only thing was this investigation, so I didn't formally file a complaint against him, no.
Well, do you know how this investigation came into being?
Like this case, or?
No, the investigation. When I'm saying investigation, I'm referring to the Farley investigation, which I believe is in front of you.
This is just the interview I had. I don't know if there was an investigation with Farley, no.
Okay. And are you saying, did you start, and I'm going to say complaint, but you might have some other word, but is the information that you gave to the DOC, is that what started the investigation into Farley or something else?
I'm not sure if there was anything that occurred with Farley, if there was an investigation after this or not.
Great. What information, if any, did you give to the DOC about Mr. Farley?
That there was a relationship between him and Stolar.
Okay.
Basically that she had informed me about an incident where she went to his home, that police were contacted. She had communications with Farley's wife, and that she basically said that there was, I believe that was the end of their relationship, but I'm not positive.
Okay, and you got all that information directly from Ms. Stolar or somewhere else?
Miss Stolar.
Okay. And then the question is why did you give that information to the Department of Corrections?
Because in this conversation I had with her on the unit, she was saying things basically that led me to believe that with the whole Teuton situation, that there were some things that she was doing that were not truthful.
Okay, what does that mean?
So it was known in the institution that there was some sort of either investigation or something going on between Stolar and Teuton.
Okay.
That due to what occurred at this fishing tournament.
Okay.
And, you know, people that were there were saying that nothing happened. Obviously, I was not there. But what she had told me basically led me to believe that she was maybe not telling the truth about the Teuton situation.
Okay. What did people tell you about what happened at the on the lake?
I heard rumors that there was an incident where everybody was drinking, I'm sure, but
Okay.
that she lifted her top. That was one rumor. There was a rumor that Teuton, felt her chest inappropriately. That was another rumor. Those were the main two that were kind of flying around.
Okay.
I was not there. I don't know what actually occurred.
Great. I appreciate that. Do you know who you heard the rumors from?
Not specifically, especially right after the fishing tournament. So whatever the next day was, that everybody was talking about it.
Oh, okay. So when you said that you had heard about rumors from Stolar, you'd also heard about them from other people, right?
Yes.
And you knew exactly what was alleged to have happened at the fishing trip, right?
Between those two rumors, that is what I had heard, yeah.
Okay. Now, at any time did you learn that there was any charges filed against Mr. Teuton?
I believe so. I think he was sent to work at a different institution, which is when it came out that there were charges filed, so they couldn't both work at the same institution. So I learned that at that point.
Okay. How did him moving to another institution lead you to understand that criminal charges have been filed against Mr. Tuton?
I mean, at the time, people were discussing it and looked it up on, CCAP or something like that, where it listed that there were charges filed.
Okay, so you had firsthand knowledge that there were charges filed, right?
Like told from.
Maybe I misunderstood you, and I'll ask a different question.
Okay.
Did you say that you looked on CCAP or somebody else?
I did not personally look at CCAP. No.
How do you know that somebody looked at CCAP?
People were discussing it.
Okay, and approximately how many people were discussing it?
50, 60. I mean, most of the shift, a first and second shift, so quite a few people.
Great. Now, was the thrust of these comments, were they pro-Teutons?
Yes.
Okay. And then, I think I need help with the timeline here.
Mm-hmm.
At some point, you're saying that you had this after you learned about the CCAP and the charges and the allegations against Mr. Teuton and there was criminal charges.
Mm-hmm.
At some point, you had a conversation with Ms. Stolar, right?
Yes.
Okay. Approximately, what's the time frame between there?
I know she was not working at Dodge for a while. I think she was working. So I'm not sure where else. She was working somewhere else, and this conversation was in August, so months of time. I'm not sure when the phishing incident happened, but from then to August would be when this conversation was.
Okay, and was Mr. Teuton back at DCI at this point?
I do not believe so, no.
Okay. And did you think that any criminal charges had been filed against Miss Stolar when she had been relocated to Madison?
No, I didn't think that.
Appreciate that. Now, did you ever give any other information to the Department of Corrections that led to any other potential discipline?
Between these two?
Ever in your entire life?
Yes.
Okay. When was that?
Valentine's Day of 2020.
Okay. So then that's the same year, right?
Yes.
And I'm not good with Valentine's Day. I've heard that before. So can you let everybody know, including the record, when that would have been?
February 14th.
Okay. And that's like somewhere slightly more than 2 weeks after the fishing trip. Is that fair?
I'm not sure but I do believe the fishing thing was in February, so yes, that would make sense. That was weeks.
Great. What information did you convey to the DOC at that point?
I was on a medical vigil with another officer, and I was sexually harassed on that medical trip, and I reported that.
Oh, okay. Mm-hmm. Who was the officer that said? I don't need to get too far into it, but I'd like to just be clear, or maybe you don't have a problem. Would you be willing to tell us what happened?
I can tell you what. Yeah.
I'd appreciate it. And if you're uncomfortable, please let us know.
Before you start, what is a medical vigil?
There was an inmate that was out at the hospital, and he was admitted. So we would drive there. He was in Fond du Lac. So this officer and I drove there. We're with him for that whole shift until we were relieved by another.
So somebody stays with somebody
Yeah,
when
they're never alone. They're
Okay.
always under at least a 2-person.
Thank you, I just didn't understand.
Sorry.
You're fine that I don't understand all this terminology,
Sure.
and I have no problem telling somebody I don't know something. So I didn't know what that meant. So thank
Sure.
you for that clarification. My apologies, Attorney Cross. I just need to know what it is.
I hope we've been good so far, but that one hadn't occurred to me. So okay.
Okay.
So I'm sorry. Can you explain to us what happened?
Mm-hmm. I was on this vigil. I remember it was Valentine's Day because the officer's last name was Cosert. He was talking about how he was very lucky to be spending Valentine's Day with me. That's how I very much remember the date. But the entire trip, on the way there, he was just talking about, again, how lucky he was to be there with me. It was odd behavior, I thought. But then On the trip, it wasn't, the inmate was very, he had dementia, he was very combative, so we spent most of the trip actively doing something. A lot of vigils, if the person's unconscious, you're just sitting there. That was not the case here. But on the way back, he was telling me, I was driving, and he was saying how attractive it is that a girl was driving him around. Then he mentioned his brother is currently, or was incarcerated for sexual assault. When we got back to the institution, we were walking in, he was behind me. He goes, well, you can't get away from me without me turning these keys in. He was telling me how the view was good from behind me. Kept making inappropriate comments.
I think we got. All right, I appreciate that. I don't mean to cut you off, but
No.
How did that make you feel?
Mad.
Okay. And when you, I guess, let me be clear. Have you said that you filed a complaint? Because I just used give information.
Yes, I had talked, the next day I had talked to another, it was a sergeant about what had happened. And she told me, that's not all right.
Mm-hmm.
You need to tell somebody. So at that point, I talked to, I cannot remember what supervisor it was, but I filed started an investigation.
Okay. And do you could we call that an intake, for lack of a better word?
Yeah.
Okay. And I guess maybe just even for the judge's benefit, can you describe what you think an intake means?
Just an initial, fact-finding interview. Try to get as much information as possible to get a list of other people you might need to speak with, just to start the investigation process, I guess.
And do you think did you give any, let me put that another way, were you interviewed during that investigation?
I know I was, obviously, when I initially gave it. I'm trying to think if there was another one. I'm not sure if I was again or not.
Okay. Do you know the outcome?
He was terminated, yes.
Okay. And did you feel when they had terminated the person for and just to be clear, there was no touching, was there?
No.
Okay. Did you feel it was appropriate for him to be terminated for making, I'm going to say, sexually harassing comments towards you?
I will say I was surprised that he was terminated. I did think there would be some discipline. I do know at the time he was pretty much brand new. He was under probation. So I don't know if that had something to do with why there wasn't other discipline before termination or what. But I was surprised that it went to that point, yes.
Okay. And do you know when he was terminated?
I'm not sure the exact time. It wasn't, it wasn't like years or anything like that.
Was it before or after Ms. Stolar left?
Before.
Okay. And were you ever sexually harassed by that correctional officer after that?
He tried talking to me in the hallway, asking me why I reported that.
Okay, and how did that make you feel?
I think, I was more so shocked that somebody, because I know at that point, obviously he was aware of this, and you were very much told not to speak to the other person in regards to the investigation. So I was pretty surprised, and obviously I reported that as well that he said that.
I got it, thank you. Okay. Now, I'm going to point you to, it's called R16, the tab 16 on there, and I believe you looked at it before. It's just a 3-page document. Okay. And I'm going to ask you to look at the second page. And where I'm going to start from says MR8. Do you see that?
Yes.
Okay, and I'm sorry, just for completeness of the record, it says BM8. Did she say anything in the bubble?
Mhm.
And then MR8 says no, she didn't talk to anybody. She was on the stairway quiet. They were arguing over the fact that Officer Bischoff went to Farley and told him that Stolar and Beck were in some type of relationship. And Stolar told Farley that the only reason Bischoff told him is that Bischoff is sleeping with Beck. And there is a rumor going around that Beck is sleeping with Stolar.
Mhm.
Did I read that part right?
Yes.
Okay. And when this rumor here that is going around at this time, and I'm sorry, can you just tell us, scratch that question, but can you just tell us when the date of you gave this interview, if you know?
Without looking at the date, no, I don't know.
Okay, with looking at the date there, refresh your recollection?
Yes, I knew it was in August. So yes.
Okay. And sorry, and now that it has, can you tell us the date, please?
August 13th of 2020.
I got it, okay. Had you learned whether or not Joanna Stolar had made any, actually retained an attorney at that point?
No.
Okay. Were you aware whether or not she had filed any complaint against the Department of Corrections?
At this point?
Yes.
No.
Okay. When were you aware that she filed a complaint with the Department of Corrections?
After she no longer worked there, there were again rumors. I didn't know for sure, honestly, until I got called for this.
Okay.
So, but there were rumors, relatively quickly after she didn't work there anymore. Again, I don't know if she was on quit or how that works. So, but after that, people were talking about how she had retained an attorney and filed a complaint with the DOC.
Okay. Were those comments pro Ms. Stolar?
No.
Oh, okay. Were they pro Mr. Touton, for example?
Yes.
Oh, okay. And approximately the same number, about 50?
Yeah.
Okay. Is it fair to say that the rumors about Ms. Stolar continued even after she left the institution?
Yes.
Okay. And you are aware that some of those rumors were about Ms. Stolar being acting like a whore, for lack of a better word, right?
That would be a word that was used, yes.
Okay. And you personally heard that word?
Yes.
And we're talking about from before the fishing trip, you heard those, right?
Yes.
Okay. And after the fishing trip, you heard that?
Yes.
Okay. And after the criminal complaint, you still heard that, right?
Yes.
Okay. Now, just going back to your quotation here, it says, Stolar told me that some guy in Seg started that rumor as a joke. Do you see that part there?
Yes.
Okay, when you say some guy in Seg, are you referring to an inmate or an officer or something else?
I believe an inmate.
Okay. And is it appropriate, I guess put another way, are there disciplinary opportunities for inmates who start rumors against officers?
Yes, there is a conduct report charge, for lack of a better word, that refers to that, yes.
Okay. Do you know if a report was written up at this time?
I am not sure, no.
Okay. And you didn't write up a report?
No.
Okay. Now, it says this was after talking to Greff and during all the hang-ups. Do you see that part?
Mm-hmm.
Okay. When you say after talking to Greff, what are you talking about there, if you know?
I believe earlier I was talking about how earlier in this interview, that Stolar had talked on the phone with Greff. So I believe I was referring to, she told me this bit of information after she had spoken with Greff on the phone and the hang-ups with Farley on the phone.
Okay. And if I just read up at the top, it said M7, it started because she was showing me her workload, and she said that every time she worked a double, she was supposed to have 24 hours off, and she showed me that after she worked a double, they only gave her off first shift, not second. Do you see that part there?
Yep.
Okay. And so does that help refresh your recollection about what we were talking about below?
Yes.
Okay. Now, just following up there, I'm just going to continue to read, but tell me if I'm doing it wrong. I know she called Greff and spoke with him, and she was upset with him. After she got off the phone, she was still extremely upset and said, I'm sick of this place fucking with me. If it continues, I'm going to blow this place up. They know what I'm capable of. Right, okay. And so why did you think that was about, what did you think that was about?
I believed that was about Teutons.
Why did you think that?
When she said they know what I'm capable of, to my knowledge at that point, the only way, or the only thing that they would know her, difficult isn't the correct word, but the only thing that they, I assume as the DOC, would know her to be difficult with would have been this Teuton situation, which is the way I took it.
And the complaints against Teuton?
Yes.
Okay. And were you clear if that was the DOC complaints against Teutons or the criminal complaints against Teutons? Both? Something else?
At the time, I guess no, I do not know which specific part, the DOC or the criminal. I guess I kind of figured that they were the same.
Okay. And is it that phrase that made you think that she was telling something other than the truth or something else?
Yes, that.
Oh, okay. So, now, you said that you had a conversation with Stolar, right? That Stolar?
Yeah.
Yeah, okay. And, but you've had more than one conversation with Stolar over the course of your experiences with her, right?
Yes.
Okay. So you knew exactly what she was talking about when she said, I'm sick of this place fucking with me, right?
I assumed she meant people talking about her and rumors is what I assumed she meant, yes.
Okay. And when you filed a sexual harassment complaint, did you do that in good faith?
We're thinking would stay confidential or?
No, that's a
what-
really good question.
Oh.
I appreciate that. When you made that complaint, did you make that complaint truthfully?
Yes, what I stated in that was truthful, yes.
Okay. And did you feel like you had a right to make that complaint?
Yes.
Okay. And did the DOC policy give you the ability to file the complaint as well?
Yeah.
Okay. And just going in reverse order, do you believe that DOC policy gave Joanna Stolar the right to file a complaint? Or the ability to? And do you think she had a right to file a complaint?
Yes, if
Okay.
she felt that way, yeah.
Okay. Do you have any reason to believe that she was filing a complaint in bad faith?
Again, I was not there, but based off of many other people's recollection of it, I believe that she was very intoxicated and might have done something that she was embarrassed by, and it got out of hand. Not saying both parties or the other party's completely innocent, but I don't know if what she reported was fully truthful.
Oh, okay. And we're clear that because you explained it to us, you understand the allegation to be that Mr. Teuton grabbed Miss Stolar's breast, right?
Yes, that was one of the rumors.
Okay. And you know that to be sexual assault, right?
Yes.
Okay. Now, correct me if I'm wrong, but it seems to me like the rumors that you were hearing influenced your view of Miss Stolar. Is that correct?
Yes.
Okay. So in other words, you believe that she was, whorish, for lack of a better word.
Objection. I don't think there's no basis for.
I think I'm going to ask for clarification because we can't go from a general her being called a whore before and after to now does she, and then we had a general thing and now we're being specific. So why don't you ask her, what is your opinion?
I didn't ask. This is cross-examination. So
I know.
I'm not asking that question. The question I'm asking was the one that I asked, which was you. I mean, you admitted to us that these rumors were, among other things, about her being a whore, right?
Yeah.
Okay. You also admitted to us that those rumors affected your opinion of Miss Stolar, right?
Yes.
Okay. And so, therefore, we can deduce fairly, can't we, that your opinion of her ultimately was that she's a whore, right?
Objection. It's the same thing. I think, I'm sorry,
She can either say that forms the basis of her belief or not. Hold on. I'm going to overrule your objection. And I think things are being conflated. But do you believe that her... Just answer his question, if you know what it was.
I will say that my conversations with her about Farley made me lose a lot more respect for her than the rumors I heard about Toutant. And it made me believe that she's not a ethical person, I guess.
So,
Based off of the Farley.
on that basis, then you reported Mr. Farley, correct?
After she told me all these things about the 4th of July incident, yes.
Okay. So to recap, you believe that she was whorish, right?
objection, that's not what she answered.
She hasn't said that she believed she was whore or whorish. What she answered was that the conversations that she's had with Miss Stolar about Farley made her lose respect for her more than any rumors she heard about Toutant.
Okay. And those, just to save you the gap there, the rumors that you heard about her with Farley was that she was sleeping with a married man, right?
That was, I heard that directly from her, yes.
Okay. But you also heard that in rumors, correct?
Yes.
Okay. And what about the statement, "They know what I'm capable of," makes you think that her, any of her previous statements were somehow less than truthful?
Just by her saying, I think based off of other conversations I had with her, that she was good at making things difficult for people, whether it be this the whole trying to think of what it'd be called, but the work schedule, how she can have 24 hours off after a double, or there were people that were doing, I can only work 8 hours a day or 40 hours a week or whatever. There were other people that did that, and that to me is making, what you sign on when you take this job, there's gonna be a lot of overtime. But she had stated that she was good at making things difficult.
Okay. Do you think it made things difficult for Mr. Toutant that Miss Stolar filed a sexual assault complaint with the police against him?
That it made his life difficult?
For example.
I'm sure it did. Yeah.
Okay, and how about do you think it made his life difficult that she filed a sexual harassment complaint with the Department of Corrections against him?
Yes.
Okay, how about Alexander Hartzheim? Do you think that made his life more difficult that she filed a complaint against him?
Objection, I don't think we had any testimony about Mr. Hartzheim here yet, so we don't have any.
Do you know who Mr. Hartzheim is?
I do. Yes.
Okay, do you know that, do you dispute that she filed a sexual harassment complaint after Mr. Hartzheim allegedly said, "Can I see your boobs"?
I had not known that there was a complaint filed against him.
Okay, but you knew that he was the origin of that allegation, is that right?
No.
The target of that
I didn't even know that he was a part of it till earlier. She had asked if I knew who he was.
Great. I just have one last question for you. Do you think it made things more difficult for the Department of Corrections that Ms. Stolar filed a complaint against Toutant?
I object. I don't think she's going to be able to answer that.
Well, let's
question.
find out if she can. I'm going to overrule the objection. She either knows or she has an opinion or doesn't have an opinion.
I don't know if one person could make this size department difficult. Just because, I mean, yes, they obviously have to put like resources to it, sure, but I don't know if it makes it difficult for them, I guess.
Why did you leave the Department of Corrections?
I left because I have a child and his father, my fiance, still works there, and one of us had to have a more reliable schedule.
Okay, no more questions.
Any redirect?
Could I ask you to look at the page that's marked 1438? I think you're open to it right now. Okay, so on that page, you had indicated that there was this incident on 4th of July.
Objection leading.
It is a leading question, but she's trying to get her back on track. So let's let's see if we can rephrase it and just ask her what you want to know about
Okay.
that incident.
When you made the report that's on page 1438, do you recall what year that was made regarding the 4th of July incident?
2020.
Sorry, I'm just trying to read through this real quick. Do you recall if there were any discussions with strike that? Did you know another employee with the last name of Seipert? Cypert?
No.
Okay. I don't have any further questions.
Okay. I have none.
Okay.
All right. Miss Roberts. I believe that's your last name. Correct. Okay. I believe we're done, ma'am.
Okay.
Thank you for participating.
Thank you.
All right. Someone want to close up that book when we walk by, and who's
Yes.
next?
I can do it.
Thanks. Oh, I thought you said her.
Oh, no.
I was like, who are you getting? Thank you.
I think he was able to move quicker than you were. Thank you, Attorney Cross.
Of course.
Do we know who's going to be next?
I was going to call Kelly Brown.
Kelly
Brown.
Brown. Let's
You
see
don't
if
know her
that's-
life history, Judge?
Who?
Kelly Brown's life history?
No, I don't know who any of these people are. Look, all I verify is that people turned in their lists. I don't go through them. All I verify is people turn in their exhibits and they're not flipped around or they're legible. I don't even read them.
I got a good one for you, Judge. So I was in college, and this guy was from Texas, if you can believe that. Everybody was from Colorado, Texas, when I went to college in Santa Fe. And we're talking about, what we learned in school and everything. And he says, do you mean to tell me that in 5th grade you don't study Texas history?
Not if you're from there. Every state tells you it's their own local history. But everything's bigger and better in Texas. Having relatives that live there. I disagree, but whatever.
The whole point is that to him it was, I'll explain the meta joke here, to him it was inconceivable that people wouldn't study Texas history because that's the history.
Okay, I have no comment on that.
Yeah, You're just declining to be a DOC nerd, Judge?
I'm done.
Okay.
I'm declining on that. No, but I'm very interested for now to figure out who this person is.
All right.
Sorry, I got my back, so I'm really sore. So if I'm getting up wandering, that's the only
you're
reason.
fine.
That's what I said. Somebody with broken back can get up and wander as much as they need to. You know, you start doing jumping jacks, we're going to have another issue. But
Yeah, I don't think I can do.
the wandering seems to be fine.
How do you spell her first name? Does anybody not remember? Is it just K-E-L-I?
Oh, I looked it up on the list. It's
Two
Kelli, and Brown is the normal spelling without an E on the end.
Awesome. Now we found it all.
Hi, hello.
Good afternoon, Miss Brown. Please make yourself comfortable.
Thank you.
Thank you for coming. Good afternoon. I'm Administrative Law Judge Larissa Benitez Morgan. If I could get you to raise your right hand. Do you affirm or swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Beginning things. If anybody asks you a question, you don't understand it, don't try to guess what they mean. Just simply say, I don't understand the question. They'll repeat it. They'll rephrase it. If for some reason somebody asks a question, before you jump right in, if you hear an attorney say, objection, stop talking. That way I could please hear what the objection is, hear from the other side, and then eventually I'll make a ruling and you'll know whether you could continue. I'm going to do better at writing down the question before somebody objects. The other thing is, nobody wants you to speculate. Okay? So you either know it or you don't know it. If you don't remember or recall, that's perfectly a good answer. Nobody wants any guessing. Okay? This was a long time ago. That being said, Attorney Zacard?
Thank you. Good afternoon. Could you tell us how you were employed?
At the time, or now?
Right now.
Okay, I am the Human Resources Program Officer for DOA, and I'm assigned to Region 2, which is DOC, and I function as the ER Chief for DOC.
Okay, that's a lot of little acronyms. Okay, and you'll find that I know what half of these do not mean, and I have no problems telling you my ignorance. So you're the HR Program Officer for DOA, and then what was the rest of that whole thing?
I'm assigned to Region 2, which
Okay.
is the Department of Corrections.
Assigned to
I function as
Region
the Employment
2.
Relations Chief.
DOC as HR Relations Chief. Thank you for my ignorance
No,
and
sorry.
enlightening me. I appreciate it. That's current, right?
Correct.
Okay.
All right, so in 2020, what was your job title?
The same.
The same, okay. Was it also the same as that you worked for the Department of Administration?
Yes.
Okay. Were you assigned to the Department of Corrections then?
Yes.
Okay. And how long have you been in that position for?
Since 2014, July of 14.
Could you tell us what your duties are?
Sure. I supervise 3 employment relations staff, and my area, those 3 ladies at this point review all of the investigation packets that are generated for the department. We assist with ensuring they're completed, and then assist with making recommendations for an outcome for those things. Me personally, I also help with policy development and modifications and ensuring that we have policies that are related to employment relations issues. We also assist supervisors and managers with employee performance problems and assist with working on performance improvement plans for that area. That's really, that's the gist of what we do right now.
Okay.
The majority of our
Excuse me, I'm sorry, I have to feed my meter. I completely forgot, and I'm getting a test. Just give me a few seconds here.
Yeah, don't trip over your water bottle.
All right.
My apologies for, we'll pause the recording. All right, we are back on the record. Parties are the same. I have sworn in Miss Kelly Brown. And we're just beginning a direct examination, and we discussed, last thing was her duties, and she talked about PIP. That acronym I know. Personnel Improvement Plan or something like that. That's what I've heard other things do. So, all right.
Just to clarify, you have 3 employees that you supervise. Do you have a supervisor?
I do.
Who is that?
Carrie Beyer.
And so you described that you do a lot of work reviewing the investigation packets. What kinds of investigation packets are those? Are those every single investigation that's done, or are there certain ones that you review?
Me personally, I only review certain ones. The ones that have to have. It's gonna be a big long discussion here. So there are certain cases that need to be reviewed by more than just my staff and division administrators. So we review off-duty claims, harassment claims, skips and progression, supervisor investigations, internal affair conducted investigations, and that's all I can think of off the top of my head.
Okay.
And it kind of changes depending on the administration too, so that's usually kind of the bulk of what stuff I get involved with, on top of when my staff call me for consultation types things.
Okay. So, just to clarify, so when you say your staff may contact you for consultation, is that the 3 that you supervise?
Correct.
Okay. And so, in terms of like an institution, do they also have human resources personnel at each institution?
Yes, they do.
Okay. So did you, as part of your duties, are you familiar with Executive Directive 5?
I'm familiar with it. I am not well versed in it.
Okay. Do you know what it's for?
It's the harassment and discrimination policy for the Department of Corrections.
And I think, I just want to back up here a little bit, I'm sorry. So can you, are you familiar with the process that is involved in reviewing these types of cases that you review? Can you maybe kind of go from when they complete the investigation through what the process is?
Sure. Do you want it from initiating the investigation to the end? Or
Yes.
just, okay. So when a supervisor is informed of potential misconduct, what they end up doing is filling out an employee investigation form. So there are specific forms that each state agency uses. It's the same form number. So it's the DOA 15807 A through H forms. And so the supervisor would fill out the A form, which is just kind of saying, this is what I know. And typically it will go to the appointing authority of that institution or the region or wherever you're at. So the appointing authority determines whether a formal staff investigation is going to be conducted. Sometimes those cases, depending on the nature of the alleged misconduct, needs to get referred to Internal Affairs Office to have them conducted. Otherwise, we have every supervisor in DOC is trained to conduct employee investigations. So it gets assigned to 2 supervisors to conduct an investigation. They meet with witnesses, they interview witnesses, they meet with the subject and interview the subject.
I'm going to interrupt.
Yes,
The 2 supervisors that conduct the investigations, are they from within DOC, like maybe at Waupun or Dodge or someplace?
yes.
Okay, thank you.
It's very rarely we go outside of DOC to have investigators come in,
So it's just literally a supervisor within
the DOC.
within the DOC at one of those institutions. So if it happened at Waupun, you would get 2 Waupun supervisors to investigate?
Most of the time, yes.
Okay.
It stays in-house, but there have been times where they'll ask somebody else to do it.
But it's definitely going to be somebody within DOC.
Yes.
Thank you.
So then those supervisors, once they have conducted their interviews, they document those on one of those 15807 forms. It's the C form. They also then, once they are done collecting evidence and document that on a different form, they write up a summary of their investigation findings, and that's another one of those forms, so that's the D form. If they feel that there's some work rules that have been violated, they'll identify what those work rules are and justify why they feel like those work rules have been violated. And then at that point, the investigation materials get submitted back to the appointing authority or their designee and the HR director. And at that point, that's when my staff come and get involved in the process. So the next step of the investigation process is to hold an infraction review team meeting. So it's the appointing authority.
I'm sorry, I got to object for the record. The officer's radio is apparently going off, and there's 2 sounds going at once here. It's extremely distracting, but also I'm concerned about the record. So maybe he could adjust his volume or do something else.
I think he's adjusted his volume down.
Great.
Sorry, there's an emergency in the Capitol.
Perfectly understandable.
Thank you, sir.
I'll be back if I can.
Okay, just to make sure I have written everything down. So once they gather everything, they write up their summary. That's the D form, whether it's work rules or whatever. Anyway, those materials get sent to HR. So they go to your department, and one of the 3 people in your department are now going to review those.
So
Somewhere there's this infraction review team.
I'll kind of step back. So the investigators will submit it back to their appointing authority and the HR director assigned at that location.
Okay. Appointing authority.
Who's that appointing authority then?
So if we're talking about an institution, specifically it's the warden.
Okay. All right.
It's now each site could have, maybe it's the warden, maybe it's the deputy warden, because they can designate someone else to be that person. So I'm just, for the sake of clarity, saying the warden gets it, the HR director at that institution will get it.
Oh.
My staff are employment relations, so you have HR and ER to help differentiate so there'll be 3 people that will meet, at least 3, for this infraction review team meeting.
Okay, so then it goes to the HR director of that institution.
Correct.
Okay, got it. Then now they have the infraction review team.
So at that point, they meet to discuss whether they have a complete investigation at that, like have they asked all the questions, have they interviewed all the necessary people, are they going to move forward with discipline and is discipline appropriate? So if the decision is yes, discipline is appropriate, they ensure that the work rules that are listed are the appropriate ones and consistent with what we've done across the DOC. And that's where my staff kind of help with that process. So if discipline is appropriate, then we move to what we call the pre-disciplinary meeting. So the investigators will meet with the subject again, and that is the subject's opportunity to provide mitigation on whatever we found as far as work rule violation.
Okay, so after there is a pre-disciplinary meeting, then is there another step in the process?
Correct. So then it all gets back to the appointing authority again and the HR director, And we hold a disciplinary action review team. And so my staff, the ER staff, will also get involved in that. They review the mitigation, and if discipline is still appropriate, that's where they discuss the level of discipline. So once that is recommended, the information also gets routed through the division administrator for their approval for the level of discipline. After that, it kind of depends on what the misconduct is, what the level of recommendation is. Sometimes the process stops there, and then other times it may go on to another review. So then we have the management advisory team, and that's where I would come in, as well as my supervisor, the Office of Diversity and Employee Services chief, the Internal Affairs Director, and a representative from legal counsel. And we look at those certain cases, the ones that I mentioned earlier, the ones that I review, to determine or to discuss what a recommended level of discipline would be. And then at that point, my supervisor, Carrie Beyer, will discuss the MAT team's recommendation with the Secretary's office.
Thank you.
There's one more step.
Okay, sorry, I forgot about.
So the MAT team's record, whatever their recommendation are, that then goes to the secretary?
Yes. And if there is a request for a skip in progression, I also need to send a request over to the labor relations chief at DOA DPM to get his approval as well.
All right, so you said there's another step after Carrie Beyer reviews it with the Secretary's office?
And that's what I was talking about, is skip and progressions have to go
Okay.
through labor relations.
Got it. So then, once there is this, I don't know what you would call it, this meeting between Ms. Beyer and the Secretary's office, then how does it end up with whatever decision is made? How does it get back down to the person who's being?
Okay. So so Carrie lets me know what the final decision is, and I email the appointing authority and the HR director, letting them know what the outcome is.
And that's the HR director at?
The local HR.
Okay. And then, do you know how HR director at an institution then informs the person who's under investigation of?
So we have to issue them, if discipline was approved, we have to issue them a discipline letter. So that is their notification that here's your suspension letter, your termination letter, whatever it is. If there is no outcome, we also issue them a no action letter. So there is some type of letter that will close out an investigation, so the employee is informed that it's been concluded.
Okay. And I just wanted to go, I'm sorry to go through this again, but I just wanted to clarify a couple of things here. So when somebody is assigned to do the investigation, whether it's a supervisor, well, it's usually two supervisors, or who else could it be?
Objection leading.
I think it's a clarifying question. She's already stated that there are two supervisors that might conduct the interview.
Sure. Still is a leading question.
I didn't finish it.
Well, I want to hear the rest of the question, and then I'll decide whether it's leading. So you're laying...
I was just going to ask her, if it's not two supervisors, who else could it be? Because she indicated it's two supervisors, or there are other situations. So I just wanted to see who else might do the interview, other than two supervisors.
I
Yes.
wouldn't object to that question.
Yeah, I'm not either. I'm kind of curious.
If it's not two supervisors, it means it's been referred to our internal affairs office, and 2 of the internal affairs investigators are assigned. It's just that they are not supervisors. But that is their job, is to do employment investigation.
Are they, and strike that, I'll come back to that. So the investigators, depending on who it is, what is their role in this? If you could just kind of explain that a little bit more thoroughly. I think you had indicated they gather evidence, but anything else?
So their role is to gather the facts. They are literally collecting evidence to prove something did or didn't happen, and asking questions of witnesses on what they know, and then interviewing the subjects, basically doing the same thing. So they do not do anything else but gather the information and summarize it and say, here you go, for someone else to look through it to make a determination. They are not decision makers.
Did you indicate earlier that they might write some, for lack of a better word, some possible violations down?
So if they get through their investigation and determine and feel like there were work rules violated, yes, they will indicate on the form which work rules they feel have been violated.
And if they write those work rules down, are those still just recommendations, or are those what decisions are made on? Does that make sense? I'm sorry.
No, I know what you're talking about. So at the infraction review team meeting, the folks that are at that meeting, again, the appointing authority, the HR director, and my employment relations staff will look at what the work rules are, and at that time, if there could be modifications made. When we train supervisors, we tell them to list every work rule that they think could be violated, whether they all kind of stay or not. But then my staff are making sure that this type of misconduct, we usually use whatever work rules, these 2 work rules. And so we try to make sure that we're being consistent across the department. So those work rules could change. They could stay the same. It really just depends.
So you indicated something about consistent across the department. Could you please explain what you mean by that?
So my staff are assigned to different institutions across the state. Obviously, the institution HR directors at Dodge are only reading investigation packets from Dodge. They're not reading them from across the state, where my staff are reading them from across the state. So they talk to each other a lot. They bounce ideas off each other a lot. Hey, I've got this going on at Dodge. Which work rules have you guys used there? And hey, these are the work rules that we've used for that same kind of misconduct at other sites, so that we're not going to an appeal hearing with similar cases, but they all have different work rules, if that makes sense.
Okay.
And we want to make sure that we're only listing work rules that we can actually support. There's a lot of work rules that overlap, and we can, instead of listing 5 or 6 on a letter, we can be solid with 2.
So now you indicated that you try to stay consistent with the rules. Do you also look at consistency in terms of what discipline is issued?
Oh, absolutely. Most of our misconduct is going to be progression unless there is a serious act of misconduct included. Those are the cases that, as I mentioned earlier, once they get discussed with the secretary's office, I also have to send it out to the labor relations chief at DPM for approval. So I keep a very large spreadsheet, because we've had a lot of them within the last few years, of situations, the descriptions, what the levels we've recommended and what levels have been approved. So my staff have access to that. Not everybody has access to that. So they're able to come into those conversations at that disciplinary action review team meeting and say, this is what we've done with other cases with the exact same situations, to make sure that we are issuing consistent discipline for the same types of misconduct.
Sorry, just checking my notes here. Alright, so, are you familiar with a discipline case that involved a person by the name of Jason Toutant?
Yes.
Oh, how is it that you were familiar with Mr. Toutant's investigation?
His would have been an off-duty misconduct, so it would have been one that we reviewed at our management advisory team.
Okay. And in terms of Mr. Toutant, was, I guess just to back up a little bit, so was the, I'm kind of getting ahead of myself, but was the off-duty misconduct something that you had a lot of, I don't know, other cases, similar cases?
No.
Okay. When you, do you recall when you first became involved in that case involving Mr. Toutant? If you recall.
I don't remember.
And perhaps I should also ask you, I mean, how many cases, if you're able to estimate, do you review a year?
How many do I review?
Yeah.
Hundreds.
Okay, okay. And I should have asked this before. So when you review all of these cases, what is it that you will review? What do you look at?
So again, we're looking to see if all the correct witnesses have been interviewed. Sometimes we are looking at it to make sure that all the questions we need asked are asked. Sometimes there are unanswered questions that maybe the investigators just didn't think about, but looking at things from the outside, it's like, okay, but why didn't you ask this question? So those are the kinds of things that we're looking for when we're reviewing investigation packets.
Okay, so just to clarify, so if you had somebody, well, first of all, what do you get in terms of the documents?
We get everything that was submitted to the appointing authority, so all the forms that are filled out up to that point and all the exhibits that have been collected.
So if you review a packet and you see that there are things that you that you weren't answered, like you had mentioned, what would you do then?
I would talk to the appointing authority and say this is what's needed, or the HR director.
When you talk to the HR director, are you asking them to obtain the information that you are missing?
Yes, we're basically saying this is what's missing from this investigation packet and we'll need it before we can discuss any further.
Okay, okay. So, sorry, I have to sign back in. Okay, so I know this, do you recall what year this case was for Mr. Toutant?
I believe it was 2020.
Okay. In terms of this case, is there anything you remember specifically that was unusual about this case, in addition to what you had indicated earlier? I know that's, let me reword that, I'm sorry. So, do you recall how long this case took to go from start to finish?
just from reviewing the documents in the last few weeks, yes, it took almost the whole year.
Okay. Do you recall why it took a whole year?
So it looks like he was charged initially with 4th degree sexual assault. We ended up placing him out on administrative leave. I'm not sure when that was. I think earlier in the year as well. And then the case kept getting postponed, rescheduled, whatnot. And it's my understanding that the secretary determined that he should be returned to work, but he was returned to a different institution, so not the same one that he had worked at. And then once the criminal case concluded, we concluded our administrative investigation.
And just to clarify, you had indicated that he was placed on administrative leave. Are there certain things that have to be followed in terms of length of time on administrative leave that you're familiar with?
Staff can be on administrative leave as long as we need to have them on administrative leave.
Okay.
There's no statute language that says it can only be for a certain amount of time.
Okay.
And he was on with pay, so that's where there's no limitations to it.
And you indicated this was 2020?
Yes.
Do you recall if there were issues regarding COVID at that time?
Well, COVID was in March of 2020, so as far as institution staff, they were working, so I don't know if there was any other. I don't work in an institution, I work in an office, so.
Okay. Do you recall if there was a point in 2020 where like office staff were working from home, or?
Yeah, I think it was March 19th of 2020.
Okay, I'm sorry.
No, it's okay. It was a Monday.
Okay. And so it's okay. Did you? Under the water. Okay. Sorry, I just lost where I was. I wanted to just ask, if a person is on probation, are there different rules that apply in terms of probationary status versus permanent status? I know that's like.
Are you talking about administrative leave? Or are you talking about investigation packets?
Just discipline.
Discipline. Yes. If someone is on an original probation, if they have misconduct and we determine that there have been work rule violations, we can just terminate their employment without having to do like progressive discipline, because the progressive discipline doesn't apply to them.
Okay. And what in terms of how does progressive discipline work generally?
So there are 4 steps to progressive discipline. You get issued a 1-day suspension, then a 3-day suspension, 5-day suspension, and then it's termination, unless there is a serious act of misconduct, which may mean we could go from you have no discipline, and then depending on what it was, we could request a termination without having to go through the steps.
And are these serious acts of misconduct for Department of Corrections employees within our Department of Corrections policies?
Yes, there's 9 that are actually in statute, and then the Department of Corrections has 5 additional ones that are located in Executive Directive 2.
wanted to direct your attention to, in the booklet, if you could please turn to, it's marked as R11 in that book. If you could flip the next page. So that is, it starts on, I think it's 1244, ERD 1244, and so that's R11, it's 1 of 135.
Just for the record, this was marked as the Planets Exhibit 4, Bates numbers 1244 through 1378. It's listed as the Teuton investigatory packet. It was marked, offered, and admitted without objection.
So, have you, are you familiar with this packet of information?
Yes, this is his discipline letter and then his investigation materials.
Okay. Did you review all of those materials back in 2020, if you recall?
Most likely, but I can't say that was certainty.
Okay. So, in terms of the packet, do you recall preparing anything specifically for this packet?
I do not.
Okay. Sorry, I'm not on that page. I apologize, I can't see this. I'm gonna make it bigger. Do you ever prepare summaries for any of these investigations?
All of the time.
Okay. Is it possible that you may have prepared a summary for this particular case?
Yes.
Do you recall if you did?
I do now. Yes.
Would it, okay, so you have seen, okay.
I mean, you've already done it, so let's just keep going.
Okay. Can you just tell me what exactly, without looking at it, just tell me what this document is that you prepared?
This is a document that gets prepared after the investigation is completed, the mitigation is reviewed, and it's going for like final approval for the level of discipline.
Okay. So what do you mean by going for final approval for level of
So
discipline?
once the disciplinary action review team meets and a recommendation is made at that point and on what we're moving forward with as far as a discipline, then this form gets filled out either by the local HR director or one of my staff or me, depending on how far this information needs to be routed through to the next, if it needs to go through the secretary's office or whatnot. So this is the information and the summary of what we're moving forward with as far as the formal discipline goes. Or the outcome of this investigation. So sometimes it's not any discipline at all. It is, there was no discipline or there were no work rules and there's no action. So this is the final outcome of the collective materials.
Okay.
Somebody tell me what page we're even looking at?
Yes, I'm sorry. It is ERD 1268, also 25 of 135
Thank you.
of, I think it's Complainants Exhibit 4. So,
It's entitled Final Conclusion. Okay.
Could you, without looking, could you please just shut that and tell me if you can recall? So can you explain what, if any, work roles were the final conclusion for Mr. Toutant?
So we have an off-duty, there's a work rule for off-duty conduct, so one of the last ones, 25 or 26.
Now, when you say work role, is that just a regular work role?
Yes, it's one of the state of Wisconsin work rules.
And what, if anything, do you remember about the like the conclusion that you prepared?
Just that there was an incident that happened. He had been charged with a misdemeanor. It got dropped, and he was issued a ticket. I can't remember what that was for. That's all I remember about looking at.
Okay. Can I also ask you to, okay, so you indicated there's a work role, and do you recall what the executive directive number is for the work roles?
It's Executive Directive 43.
Okay. Could I ask you to turn to tab 6? And you could flip, yeah, the next page. Have you seen that document before?
Yes.
What is that document?
This is the executive directive that lists the state of Wisconsin work rules.
Okay. And what is the title of that document?
Executive directive number 43, work rules.
And I believe that is ERD pages 1162 to 1164.
One moment, please. Give me those numbers again. 1162 is where we're starting?
Correct. And 1164 is the last page.
I'm just looking to make sure we haven't already admitted these. I'm not saying it. Okay, this is going to be Respondents Exhibit 56, beginning at 1160 ERD 1162. This is going to be Executive Directive number 43, and we ended on 1164. I have marked it. Are you offering it?
Yes.
Any
No
objection?
None.
Admitted without objection. Please continue.
Thank you. Sorry, I know I'm on the wrong page. So, just to clarify, and just to make the record clear, is the work rule that Mr. Toutant violated contained within this document that's been marked?
Yes.
What number is it and what page?
25 at the bottom of 203, 203.
And so what was the ultimate discipline that was issued for Mr. Touchant?
I believe it was a 1 day.
Is he a permanent employee at the time?
I believe so, yes.
And can you please explain why Mr. Touchant, if you know, received a 1-day suspension?
Objection. She can't know. We've already had the testimony that she's not Kevin Carr and that Kevin Carr is the person who made the decision. So she can't know how the decision was made.
I can rephrase it to ask her if she knows what her opinion is about why there was a 1-day suspension.
I think she can speak to the recommendation,
Mm-hmm.
but as to the ultimate decision, if she's not the person who signs off on it, according to her own testimony, that it has to go to higher ups. She obviously has reviewed stuff. If she feels something's missing, she sends it back. So.
I wouldn't have an objection to the second question she asked,
Okay.
if we're clear.
I'm sorry, can you repeat what the question was?
I'm sorry, I'm probably going to reword it. I'll try and reword it as closely as I can. So could you tell us what your recommendation, did you give a recommendation, first of all, on this case?
I don't believe I actually did.
Okay. Are you able to give us opinion as to what your thoughts were about what discipline should be done on this case?
Sure. We haven't had a lot of off-duty misconduct type cases that have gone through and had investigations. The few that we did have and that had been appealed to the Wisconsin Employment Relations Commission which is like the third step of the grievance process, and we have had cases overturned that were off-duty misconduct cases. The commissioners, I think there was more than one at the time, or the ALJs didn't really support DOC disciplining staff for their off-duty misconduct. So I believe the discussions were what's going to actually stick. So we felt comfortable with issuing a 1-day suspension. The fact that the ultimate criminal case determined that it was just a ticket kind of made us a little apprehensive of doing anything further either, because we had not been issuing probably even progressive discipline for someone who received a ticket.
Move to strike. Objection. To all of the answer that said "we" was not responsive to the question.
When you say "we," are you referring to you personally, or are you referring to the general DOC "we"?
The general DOC.
I think that clarifies that answer. I would have agreed with you had it been the other. Okay. So I'm not going to strike that, but make sure you have to differentiate between your personal knowledge and beliefs. Okay? And since you were part of this is what I don't understand. So I need some clarification because I might change my mind. The question is do you have, in reviewing this packet and everything else that you do, a discipline was issued for a 1-day suspension. You've already testified that your office reviews things to make sure everybody's consistent, right?
Correct.
And a variety of things. And for it was the recommendation that came out was a 1-day suspension. This was off duty. These things are usually treated differently than something happening on work premises. Also, there was a criminal case that he received a ticket for. So are you saying all of those things came into play with the recommendation that was made by DOC?
Yes.
Objection, Judge. There's no facts and foundation that the DOC made a recommendation to the DOC. I mean, that's simply not what the testimony is, and it's not possible. With the question which is asked in the testimony is that this witness was part of an MAT team that then, as we had testified by Ms. Beyer, who is the nominal head of that team, she then takes that recommendation of that team.
We haven't even gone to that
and then
yet.
takes that to Mr. Carr. No, that's the testimony that's in the record here.
It is the testimony that's in the record there, but we're not there yet.
Sure, but for her to testify that DOC made a recommendation, that's not true.
Okay, well, then we'll strike that DOC made a recommendation. Your department reviews the packet that comes up. For discrepancies, for clarification, you send it back down to the appointing authority, the HR director for that given facility. Okay? Then once they gather all that information, does your department then review it again?
Yes.
Ultimately, does it then go to the MAT team?
For this particular case, yes.
Okay. Were you involved with the MAT team?
Yes.
Were you part of the MAT team?
Yes.
Are you aware of what the MAT team ultimately decided, and did you play a role in that?
We discussed this, yes, and we all made the same recommendation.
We hadn't gotten there yet.
Okay.
All right?
I guess I understood everything you said. I understand the question. I'm going to repeat my objection here that the DOC recommending to the DOC is not the evidence and preposterous. But otherwise, I understand everything you said. I understand the questions, and I'm ready to proceed.
Okay. Well, there are different subgroups within the DOC. My terminology was probably incorrect with all the different acronyms, but the various subparts within the DOC, it's not like they're reporting to the Department of Energy. Okay? We're all still dealing under this
Sure, but the
umbrella.
testimony is that none of these people are decision makers, and the only decision maker is Kevin Carr.
Nobody's asking about the ultimate
Great.
It was the recommendation.
Sure, it's the word DOC. That to me means Kevin Carr.
Okay, well, that's how you interpret it, and you're welcome to that interpretation. I'm looking at the agency as opposed to the individual. That would be like, ERD means me. No, I'm just one of the ALJs. There's a whole bunch of us. And that's the way I interpreted that definition. But again, we all have different rules. I think it's clarified now that this was a recommendation. Where does it go now?
After the MAT recommendation,
Yes.
that's when Carrie Beyer met with the Secretary's office with the recommendation.
That's all I have. You can continue, Mr. Card.
Okay, thank you. And just to clarify, because we were discussing Matt, what were some of the considerations that were looked at by Matt in terms of recommendations?
I don't remember.
Do you recall how, or actually, let me strike that. I believe, did you testify that you heard that Mr. Toutant was placed placed on administrative leave?
Yes.
Do you recall how you were informed of that?
I actually we have a SharePoint site that the local HR directors have to add people to an administrative leave list. And every week I have to make sure it's all updated and I send the report out to our executive team.
So that's something you do on a weekly basis as part of your
Yes.
job duties? Was that how you would have been informed in 2020 regarding Mr. Toutant?
Yes, there's not like a separate notification sent to me or my staff. It's show up on the log.
Do you recall whether or not there were any concerns about contact between Mr. Toutant and Ms. Stolar?
I don't.
In general, are there any situations where you may have to assist with, issues between staff and handicap?
I've only had calls when someone has said this person has a restraining order against one of their coworkers. They called me and asked for advice.
And do you recall what types of recommendations are made in a situation like that?
We try to make sure that the institution management teams are not forcing a violation of the order. So we kind of look at who's working what shift, and if they're working 2 different shifts, it actually works out pretty nicely. If they're working the same shift, we basically tell the person, don't contact the other one. If there's a business need to contact them, you can do that, but other than that, that's all that I can remember that we've ever done.
So you had indicated that was the packet regarding Mr. Toutant, and I believe it's already marked as Complainants Exhibit 4. Do you recall whether or not you had to make any requests for additional information on that one?
I wouldn't have been the one reviewing it initially. That would have been one of my staff, so I don't recall.
Okay. And sorry, I'm just checking through my exhibits. Are you aware of any complaints about any ongoing issues regarding Mr. Toutant?
No.
Okay. And just to clarify, do you ever have to address any types of work restrictions, or is that generally a different department employee that would handle things like work restrictions or FMLA?
I don't handle any type of medical work restrictions.
Okay, I just wanted to clarify that. So this event was considered by Human Resources or yourself as a non-work event, is that right?
Correct.
Okay. And were you involved in any way in any investigation regarding an employee by the name of Alexander Hartzine?
The name sounds familiar, but I I might have reviewed the packet, but that,
Do you review packets if there's no action taken?
it depends on who conducted the investigation and whether it was something that ended up going through the management advisory team.
Um,
Okay, so, last I heard, you're not aware of any you did not review any investigation packet regarding Mr. Hartsheim, but, or you can't recall, you might have, you just don't know.
Correct.
Okay.
They don't want things recorded in the hallway that are personal matters.
I don't know what that means.
Excuse me.
Please don't touch my phone.
Okay,
I don't have any further questions.
okay. All right,
Great.
so we're now going to do cross-examination. So Mr. Hitchcock, Attorney Hitchcock Cross is going to now ask you a few questions.
Are you ready? Does anybody need any time?
Yeah,
Do you need a break or anything before we start?
I might go to the bathroom.
actually, could we please just put something on the record? Did a police officer just come in here and hand Mr. Hitchcock Cross his cell phone and say something about they don't want you recording personal things in the hallway? And then Mr. Hitchcock Cross said, please don't touch my cell phone, and put it back in the hallway?
Yes, I'll place on,
Okay.
yes, you've just placed that on the
Yes.
record. It is getting, it's 3 o'clock.
I'm sorry.
There was a officer, and I'm not sure who his name, John
King.
It's John something.
King.
Okay. Officer, Capitol Police Officer King, I don't know his rank.
Looks like a corporal.
Okay, I don't know his rank. Could be corporal. He's been sitting in here off and on. He came in because we get somebody different at the end of the day. That's what they did yesterday. So I'm guessing that's what we're kind of doing, but it's only 3 o'clock. So I'm not sure what's going on as to why they're here. He got up to leave to speak to the other officer that had been here earlier, which I believe is Hyatt.
Andrew Hyatt.
Okay. Officer Hyatt, and then they spoke in the hallway. One officer came in. I'm trying to listen to testimony. I looked over. I don't know which one said what, but somebody, Attorney Hitchcock Cross, got up from the table, opened the door, set his phone in the hallway, closed the door to return to the table. He didn't make any comments during the testimony, but my peripheral, he's right next to me. That much I saw. He put his phone on the floor. He closed the door, sat back down to finish hearing testimony. An officer returned to the room, handed him his phone, and said something to the effect of, we or I don't know. But to basically, no recording of personal things in the hallway. Handed him back his phone. Attorney Hitchcock Cross got up, opened the door, set his phone on the ground, and did say, please don't touch my phone. He shut the door, leaving his phone out there, and then sat here. And now we have Attorney Olmstead having just placed that on the record. It's now on the record again, but we're here for cross-examination. I believe Attorney Hitchcock Cross had asked, are we ready to begin? Does anybody need a break? I don't know if you would like a break, sir, but before we begin cross, if it is, we're going to keep it brief, maybe 10, 15 minutes at most.
I was thinking like 3.
Well,
If people want more time, it's perfectly fine, but I wasn't asking for any more than 3. I just wanted to go, now that I suggested it, the idea of going to the bathroom occurred to me, and I'd like to follow up on that concept.
absolutely, you may go to the restaurant.
Thank you so
If
much.
anybody else well, 3 is non-existent. It's going to take you that long. If we're going to do it, let's just do 10. and just call it a day, okay? So 10 minutes, everyone, please. It's almost 3:05, so just be back by 3:15. All right, we are back on the record on CR 2020 02513. Appearances are the same. We are beginning the cross-examination of Miss Kelly Brown, attorney Cross.
Thank you. Ms. Brown, we've worked together before, right?
You and I?
Yeah.
Yes.
Okay. And the last time I think we met was virtually in the Novak case. Is that true?
We had to return
Oh, thank you very much. We'll skip over that other hearing for a moment or two, if you don't mind.
Sure.
Great. Everything that you gave testimony in the Novak case, right?
Yes.
The testimony was under oath?
Yes.
Everything you said in there was true?
Yes.
Now, please describe for us here in this case what you understand Joanna Stolar's allegations against Jason Touton were.
I am unaware what. You mean for the investigation?
Yes, ma'am.
She alleged that he grabbed her,
Okay. Any particular part?
her breast.
Okay. And you knew that when I asked you the question, right?
Yes.
Okay. Now, what about Mr. Hartzheim? Are you aware of any complaint that she made against Mr. Hartzheim?
No.
How about Miss Miller, Lieutenant Miller? Are you aware of any complaint she made against Lieutenant Miller?
No.
No. Okay. So the only investigation that you know about with this case is the Touton one. Fair?
Yes.
Okay. Now, in the Touton one, you knew the whole time that the institution had no part in that investigation, right?
Objection. Could you, I'm sorry, can you repeat that question?
Sure. You know that the institution had no part in the investigation in the Touton matter, don't you?
Objection, could you, it's kind of vague, I don't know what.
Do you understand the word institution?
Yes.
Okay. What's your understanding of the word institution?
Like Dodge is an institution, a facility where we're housing persons that are here.
Great. And you know what an appointing authority is, right?
Yes.
Okay. And I think there's at least one of them at this time was Kevin Carr. Is that true?
He was the appointing authority for Department of Corrections, yes.
Okay. But, and his, there's also another appointing authority, correct?
Well, he delegates his authority to other people.
Thank you so much. So in the institution that Joanna Stolar was working in, who was the actual delegated appointed authority, if you know?
The warden,
Okay. And how do you know that?
because the wardens are delegated appointing authority of their institution.
Okay. And so, and that's by statute, right?
I don't know.
How do you know that wardens are the appointing authority of their institution?
There's delegation agreements that are written up, and I don't know if that's a statute thing. That is not something that I'm involved in.
Got it. Now, the appointing authority, they're the one who's supposed to be making the decision on any discipline, right?
They make a recommendation.
The appointing authority makes a recommendation. Is that true?
Well, of the institution appointing authority, is that what we're talking about, or Kevin Carr?
No,
Or the-
but you just testified that Kevin Carr delegated his authority to the warden at the institution, didn't you?
He delegates some of his authority.
Oh, what authority does he reserve?
I can't answer that.
Oh, and what could you point to that would show us what he reserves? What authority he reserves, if any?
Objection, I think she's already indicated she doesn't know what authority is appointed.
Great. Can you answer my question, please?
Can you please repeat your question?
Sure.
Hold
What
on.
document can you point to?
Hold on, please, everyone. We first figured out that there's a whole bunch of different institutions, which are basically all these facilities, and that Secretary Carr was appointing authority back in time when all this happened, and the testimony's been that he delegates some of his appointing authority to the warden. She has no clue where that comes from, the statute or whatever. That's her understanding, and then it just got jumbled from there.
Great. Okay. So, sitting here today,
can you point to any document, reference anything, statute rule, anything you want, that would show us here what appointing authority powers Kevin Carr reserved at that time?
Objection. I don't think that there's a sufficient basis here for her to be able to provide testimony, which essentially sounds like legal argument. She just testified she knows that there's some authority appointed and she's not sure what or under what basis. So I don't think that this is an appropriate witness to ask this question.
If she knows, she knows. If she doesn't, she doesn't. And I think she's clearly indicated that she doesn't know the answer to your question. I don't know how many times you can ask the question and she still doesn't know it. She can't point to a statute. She's already said she doesn't know what statute, what authority, what anything, but that's her understanding.
No, she hasn't actually been able to answer the question because counsel opposing, again, made an objection that was not a non-objection. That's what in fact happened.
I don't know that was a non-objection. So this is what I'm going to do. I'm going to allow Attorney Hitchcock-Ross to please state whatever question it is that he wanted to ask.
Great. For the third time, it's simply this. Sitting here today, you are not able to point to any document, authority, or anything else that would show us what, if any, powers that Kevin Carr, or appointing authority powers that Kevin Carr retained. Correct?
Correct.
Okay. Now, who was the warden over Dodge at that time?
I don't remember.
Could it have been Jason Benzel?
It could have been, yes.
Okay. And now, if the warden isn't the one who's actually making the decision for the, and sorry, do you know whether or not Warden Benzel made the decision to issue a one-day suspension?
He was part of the recommendation and he signed the letter.
Okay. So he signed the letter issuing the suspension, but he didn't actually have the authority to do that, or something else?
He had the authority to sign the letter, yes.
Okay. But he didn't have the authority to issue the one-day suspension, correct?
Not without all the approvals that we have internally.
Okay. So in fact, it wasn't the warden's decision at all, correct?
I don't know how to answer that because he made that recommendation and I guess it was finally approved by the Secretary's office to issue the one day.
So is it your understanding that the Secretary is approving the decision that the warden made, or something else?
For this particular case, that is my understanding.
Okay. Did the warden make the decision? Did the Secretary make the decision?
I guess ultimately the Secretary made the decision.
Okay. And you've known that the whole time today, right?
I don't know how to answer that because, like I said, the wardens make a recommendation and it just gets approved by the Secretary's office.
Oh, so the Secretary doesn't the Secretary doesn't, for example, weigh the pluses and the minuses when he makes a decision?
Objection, lack of knowledge. I don't think she's testified that she's in the meetings.
I'm going to sustain that because she already said that there was somebody else that actually takes those recommendations from the MAC group and along with a summary of what happens to the Secretary, and then meets with them answering any further questions, getting whatever further information they need. And there's been no testimony that Ms. Brown is the one that actually meets with the Secretary.
Great.
So I think you need to establish that she's part of that meeting.
Well, you weren't part of that meeting, were you?
I am not.
Okay. Now, you also mentioned earlier in your testimony with Ms. Zacard that there is another step with the Department of Administration, right?
Correct.
Okay.
And what is that step?
So if the recommendation is for a skip in progression, then I need to send materials to the labor relations chief at DPM to get their approval.
And you know, and have testified earlier, that the secretary is going to outrank DPM, right?
Objection? Foundation, there's nothing here.
You just had her testify about this, and I'm asking her now about the questions that you had her answer. What we're talking about is, I don't even know how this is an objection, but what we're testifying is that if there's a script of progression, there needs to be this additional check here. You had her testify to it, and now you're saying that there's a lack of foundation. I'm aghast.
You're jumping from, here's the process if there is a skip in progression, assuming there was a skip in progression in this case, and then also jumping from that to saying that the secretary has more authority than DPM. I don't see the connection there. There's no foundation that gets you from A to whatever letter.
Just it's simply not even an objection.
That is an objection.
That
Just
she doesn't
because you
see
don't
the
like
connection is not.
The
is not an
objection was
objection.
asked to form, and then she elaborated what she meant by form. And the form of the question and your position is that she did testify to those things, and I'm in agreement with the respondent. That is not exactly what she testified to, and it's a misrepresentation of her former testimony. You can get there, sir, by asking those questions that were missed.
The problem here, Judge, is that the testimony that I was referring to is her previous testimony in the Novak case.
I don't know anything about the Novak case.
Okay, but who
Nothing's
said
come in.
How is that an objection?
Attorney Cross.
Okay, understand, everybody. Okay, what she testified to in the Nova case is basically that whatever she said at that hearing, which I don't understand how that has any bearing to the issue before me. It's never been provided to me. I don't have any exhibits from that testimony. I don't know what's been said, what hasn't been said, but that's the very first thing you started with. Do I know you?
Right.
I think so. Did you testify in the Novak hearing?
Mm-hmm.
Yes, she gave testimony. Was whatever you said in the Novak testimony, is it your position here today that you were truthful during that testimony? Yes. And then we move on to Carr. Okay? I'm at a loss for what Novak has to do with any of these things. But if you're now saying that you're cross-examining her based on some other type of testimony that she gave in another hearing, then you most definitely need to lay a better foundation as to what that testimony was. And again, there's been nothing submitted as to anything. I mean, I don't know what this is. If this is impeachment or what you're trying to do. We're here for cross, and I'm all about you can cross her on pretty much anything, but it's just not being clear how you're going from one thing to another, because I'm relying on the testimony that you're saying has just been given, and it most certainly has not been given in this hearing. Now I'm hearing it's from something previous in another hearing that I know nothing about.
And for the record, Judge, I didn't say that. She is the one who said that. I just simply asked she is Michelle Zacard. I simply asked this witness the question of wasn't she aware of who is the person who makes the decision? Is it the secretary or is it a DPM? That's the only question I asked. What you were going off of is what she said. Can you please, I will withdraw the question and I'll ask another question. Hopefully I'll be permitted to ask this question. Will you kindly turn to Exhibit 12 in that sheet? What is this document, if you know?
This is our disciplinary action routing form that was used at the time for Jason Touton's investigation discipline recommendation.
Okay. And do you see DPM in there?
There is a list or a row for them, yes.
Okay. Is there anything written down there?
No.
Okay. So does the DPM help us in figuring out how this decision was made in any way?
DPM was not involved in this at all.
Great, thank you so much for that. And then you see Secretary Office, you see that on there?
Yes.
That's 12/3 of 2020?
Yes.
Okay, in Teams meeting with Secretary Carr, progression was approved. Do you see that there?
Yes.
Are you Carrie Beyer?
I am not.
Okay. Do you understand who the division administrator is?
Yes.
Okay. Are they also appointing authorities?
Yes.
Okay. Now, Magda Fesahaya, she was the boss of the warden at that time, right?
She was Doug Percy was most likely the supervisor of Jason Benzel.
Doug Percy was the immediate supervisor, right?
Yes.
Okay, because he's the assistant administrator, right?
Correct.
And there's 2 assistant administrators, right?
Correct.
Okay. And then at that time, Magda Fesahaya was the division administrator, right?
Yes.
And as pursuant to her authority as appointing authority, she had the power to fire the warden, for example, right?
She could make a recommendation on it, yes.
Okay. But you're saying the only person who could fire the warden is the secretary?
He would make the final. So we have this routing process through the DOC, so everybody puts their recommendation on there, and the secretary would probably be the one that would make the ultimate decision.
Okay. And that's
Or the
all.
warden.
You knew that, right?
Yes, I just explained it.
Okay. Well, but you knew that when you were talking about DPM before, right?
Objection, that's argumentative.
What's the
I'm
argument?
going, I'm overruled. Ask the question, please.
Sure. When you went over DPM earlier with my colleague across the way here, you knew that DPM was not involved in this case, right?
In this particular case,
Right.
yes, I did know that.
Okay. Thank you. Now, you know what internal affairs is, don't you?
Yes,
How do you know what internal affairs is?
because I work with the internal affairs director frequently on cases, and she's part of the management advisory team.
That's Chrissy Preston, isn't it?
Yes.
Who's her immediate supervisor at this time?
Honestly, I have no idea. It's somebody in the secretary's office.
Was it Amy Pahacek?
It might have been, I don't know.
Okay. So, my understanding of your role in this MAT team is just to look for comparable disciplines, right?
I kind of run the MAT team, me personally. I set the meeting up. I make sure we have the cases that we're going to discuss, ready to discuss, and at that point, the recommendations and the comparables have already been done.
Okay. And your supervisor is at that meeting, right?
Yes.
Okay. And when you say you kind of run it, do you run it on behalf of your supervisor or something else?
No, I facilitate the meeting.
Okay.
Sorry.
So you don't really run it?
I used those words interchangeably.
I got it. Okay. Who's the highest ranking person at that MAT meeting for Mr. Touton?
Carrie Beyer, I guess, is as the HR director. We also have somebody from legal counsel, so I don't know if you would consider them equals or not.
Well, what do you consider?
I guess Carrie Beyer is then the highest ranking person.
Okay. Did you discuss your recommendation with Carrie Beyer before the MAT meeting?
No,
Okay.
not that I remember.
Okay. Did you communicate with Ms. Beyer in any regard regarding your the MAT meeting before it happened?
I might have because
Objection. No, sorry, withdraw.
So what I end up doing so the MAT meetings are typically scheduled on a Monday. I send summaries via email like on a Friday. That would be my discussion before a MAT meeting.
Okay. Did you ever determine whether the Lake Emily fishing trip was off duty?
I did not.
Okay. Do you know how it was determined that the Lake Emily fishing trip was off duty?
Oh, I'm sorry. I guess I misunderstood the previous question. It was not something that happened at the facility, so it was off duty.
Okay. So that's a clear line
Anything that doesn't take place at the facility is therefore off-duty. Is that my understanding?
No, I wouldn't say that is a clear line, but in this particular case, it was not a function that was work-related.
Okay, and what did you do to investigate whether or not it was work-related?
I didn't do anything.
Okay. Did any of your subordinates do anything to determine whether or not it was work-related?
I don't know.
Oh, okay. And so at what point did you accept the assumption that it was not work-related?
I guess when I read the investigation packet and said they were out fishing.
Oh, okay. And it was on that determination?
That was part of it, I guess.
Okay, did you ever look at the invitation, for example?
I did not.
Oh, okay. Now, you explained to us that the secretary, I'm assuming this is Secretary Carr, decided that he, I assume that's Mr. Toutant, needed to go back to work. Did I understand that right?
That's my understanding, yes.
Okay. How did you form that understanding that Mr. Carr made that decision at any time?
Because he had been removed from the administrative leave log and it says he was going to be returning to work.
Okay.
I don't recall if I was informed any other way or not.
How do you come to the belief that Mr. Carr had any involvement in that decision?
Because once someone is on administrative leave, usually it's the secretary's office. If they are not disciplined, they are not returned to work unless the discipline is concluded or the secretary's office makes a decision to bring them back.
Okay. And you knew the whole time that Chrissy Preston headed the investigation into this Toutant matter, right?
Objection. There's no foundation. Like a foundation.
I thought we went through Chrissy Preston and Internal Affairs before. Did I miss that?
Yes, sir.
Okay. It's late in the day. I hope you all forgive me. You know who Chrissy Preston is?
Yes,
Okay. And is she the head of Internal Affairs?
yes,
Okay. And I thought we had just asked, because this I distinctly remember, she has a supervisor, right?
yes.
Okay. And you're not clear if that person is Amy Petracek or something else?
I don't know.
Okay. And what, do you know who created Internal Affairs?
No.
No, okay. When was the first time you had any work with Internal Affairs?
Whenever they were created, which I don't remember when. It's
Okay.
been years.
Prior, was that in the Carr administration or some other time?
I believe it was the Akar administration. I'm not completely sure.
Great. And prior to the Internal Affairs, or I guess my understanding is the recreation of Internal Affairs, how were investigations handled at the DOC, if you know?
Two supervisors are assigned to do investigations, so that's still part of our process now. Internal Affairs does not conduct every single investigation.
Great. And that was the process that you went over with my colleague there, Mr. Card, right?
Yes.
Okay. But in this case, in the Toutant investigation, the only one you know anything about, you know that Internal Affairs was involved, right?
Yes.
Okay. Can you explain to me when you knew that Internal Affairs was involved in this case?
Probably at the time that I reviewed any investigation material.
Okay, and so before you testified here today about how investigations are performed at the institution level?
I'm sorry, can you repeat that?
Yes. When you discovered that Internal Affairs was involved in the only investigation which you have any knowledge about in this case, that was before you testified under oath in this case here today, right?
I'm sorry, I'm still not following what your question is.
Great. First, we'll break it down. First question, and I think you already answered this, so excuse me. I believe I asked, when did you first become aware that Internal Affairs was involved in this investigation? And I believe you said something like, when I first reviewed it.
Correct.
Okay. And then now my follow-up to that is going to be this. That period in time when you first reviewed it, it was before today, right?
Yes.
Okay. And so not only that, you knew that Internal Affairs investigated this, participated in this investigation when you gave testimonial answers in response to Ms. Akard's questions earlier, right?
Yes.
Okay. Is Ms. Akard going to help you answer the question anyway?
No.
Okay. So why didn't you tell us earlier about Internal Affairs?
Objection. I think she did indicate Internal Affairs was involved. That's all you can answer.
One moment. She discussed that internal affairs, her boss, which is what my notes say, which we've already determined, I believe, is Miss Byer, as far as who's part of that MAC group. And that's when she said the IR director, Miss Byer, representative from legal counsel, and there was one other name that I missed that my notes say check on recording for that other name. So if that's one instance where she's already mentioned that internal affairs was there. And then she's also discussed internal affairs when in dealing with conduct, that certain conduct sometimes gets sent out if you can't, if we don't have the two supervisors from the various facilities. If not, then it's usually, if it's not going to be done with the two supervisors at the facilities, then it gets sent out and is assigned to internal affairs. Basically, usually staff investigates whatever conduct it is, and that's done by two supervisors. But sensitive and other types of misconduct, well, I don't see, no, that's not sensitive. It says sometimes it also goes to investigative or internal affairs.
Okay, I'll withdraw the question. What is your understanding of the division line between investigations that are handled at the institution, or like in this case, investigations that are handled at with internal affairs?
So internal affairs has established a requirement that certain types of cases must be referred to them.
Okay, why was this case referred to internal affairs, if you know?
Why was it?
Yeah.
Because I don't believe it had to be referred to internal affairs, because not all off-duty cases have to be referred to internal affairs. So it might have been just the decision made either at the institution or division level.
Who had the authority to make that decision?
I believe it's the warden can make that decision.
Okay. Do you know what document would show us who made that decision, if anyone?
I don't know, because I don't know what there's a referral sheet, but I don't know what the name of the document is.
Okay. So you don't, just to be clear, you don't know who made this decision to sign this to internal affairs, right?
Correct.
And you also don't know why?
Correct.
Okay. Do you know what the general criteria are for putting things up into, let me put that another way, because do you know, is there a document, is there some other policy that says that some cases should go to internal affairs, other cases should go at the institution?
Yeah, so Christy Preston she has a Word document, I know this for sure, that says these are the types of cases that must be referred to internal affairs. I am not sure if it is actually in our investigations policy or not.
How do you know that document exists?
Because I have a copy of it.
Great. Have you provided to these attorneys at any time?
I don't know if I did or not.
Okay. And I'm going to ask you about another document. There was a spreadsheet that you mentioned earlier. Is that right?
Yes.
Okay. What was that spreadsheet? What's its purpose?
Are you talking about my list of skips in progression spreadsheet?
Fantastic. Okay. And who authored that spreadsheet?
I did.
Who have you sent it to?
I haven't sent that spreadsheet to anybody.
Okay. And that would include these two attorneys sitting here today?
I don't believe I sent the entire spreadsheet to them.
Have you sent them parts of the spreadsheet?
I might have.
Do you have any recollection of sending them parts of the spreadsheet?
Not off the top of my head. No.
Okay. Why do you think you might have sent it to them?
When we are listing out comparable or trying to determine if there's comparable cases, my staff and myself will take snippets of the spreadsheet and use that as a discussion point. So parts of the spreadsheet has been sent to numerous people.
I got it. And without telling me what your conversations with them were, these attorneys were, did you ever have any communications with these attorneys prior to your testimony here today?
Hearing prep,
Okay, when was that?
3 weeks ago maybe,
Okay, how about in January?
January of this year.
Yeah.
I might have, I don't remember.
Okay. And at that meeting, let's put it that way, did you leave that meeting with the impression that somebody other than Kevin Carr had made the decision in the Toutant investigation?
I don't remember.
You don't remember. Okay. Was there ever a time that you believed that somebody other than Kevin Carr had decision-making, participated in the ultimate decision-making in the Toutant case?
Not that I know of.
Okay. And that includes the times that you met with these attorneys, right?
Objection. Relevance.
Well, she's already started, and she can't recall any other time that she met with anybody that doesn't know that anybody other than Carr did that. I'm not sure we're gonna progress into what may be attorney-client privilege conversations.
I hope not. I sure hope not.
I sure hope not too.
All right.
But she can't recall anything.
Okay.
Is the last one where we left off.
Great. And you didn't hear me ask you any questions about what your attorney said to you, did you?
No.
Okay. Did you review, I think you said you reviewed some documents in preparation for your testimony here today. What were those documents?
I briefly looked over his investigation, and that was really about it.
Okay. Do you know why the secretary decided that Mr. Toutant needed to go back to work?
No.
Okay. Are you aware of a complaint? I'm sorry, I'm blanking on the last name. Her first name is Mackenzie. Her last name is Roberts. Filed in February of 2020.
No.
Okay. Now, with regard to the allegation that Mr. Toutant grabbed Ms. Stolar's breast, what steps did you personally take to ensure that such a thing would not happen again?
Objection, lack of foundation. I don't think we've established that she personally has to take steps.
I'm gonna allow the question. She either did something or she didn't. I mean, that's kind of a simple one. What steps did she personally do? If there were none, there were none.
None.
Okay, and why not?
I am not an appointing authority. I don't have that capability of, I don't handle institution issues like that. It's not part of my job.
Why do you believe that?
Why do I believe it's not part of my job?
Right.
I don't work at an institution. I review investigation packets and supervise 3 staff. That's not my responsibility.
Okay, so if you learn of any sexual harassment or allegations of sexual, we'll say assault here, is it your testimony here today that you have no duty of any kind?
Objection. Lack of foundation. I don't think that's what she said.
Well, it's not what she said. I understand the question of what he's trying to ask. She's already explained in the very beginning of her testimony just exactly what her job duties are and what she does. She doesn't work in a facility because I had to get that clarified as to what the heck we were talking about. They're actually...
I can withdraw the question. I
Okay.
understand what's going on and I can handle that. You understand what a mandatory reporter is?
Do I understand what it is?
Yeah.
Objection. There's no foundation for that definition in mandatory reporter.
Well, we don't even know what a definition is. He's just simply asking, he could ask her, do you understand, is an orange a fruit? This is cross. He can ask her if she understands the definition. That definition has a variety of definitions. That's up to her to figure it out, what it is he's asking. But he can ask her if she understands what it means. And then you can tell them what you think it means. I mean, let's go. Attorney Cross is fine.
Can you please answer the question that I asked you?
Can you please ask it again?
Yes, do you know what a mandatory reporter is?
I believe I do.
Okay, why do you have that knowledge? I'm going to withdraw that question. Is that related to your employment at Department of Corrections?
To be a mandatory reporter?
That's
no,
right.
it is not.
Okay. I believe I heard from Miss Byer the phrase something like "made aware of." Are you aware of that phrase?
Yes.
Okay, what does that mean at the Department of Corrections, if you know?
Somebody tells me something, so now I've been made aware of.
Okay, and then do you have to do something or no?
I believe it depends on what the situation is.
Okay, so let's focus that down. I appreciate that. Point blank, do you believe if you're aware of act of sexual harassment that you have any duties under the DOC policies?
Yes.
Okay, why do you believe that?
Because ED5 tells me that I do.
Okay, and that's the one that you're familiar with, but you don't know it in detail. Is that true?
Correct.
Okay. Now, the only person above you at the Department of Administration that helps enforce that for the Department of Corrections is your supervisor, Ms. Byer, right?
She's my supervisor, yes.
Okay, but you're pretty high up on the totem pole for HR, true?
Yes.
Okay. So wouldn't it behoove you to be familiar with this rule?
Objection, it's argumentative.
That is argumentative. Rephrase.
Okay. Could it help you with fulfilling your job titles to have more familiarity with this job duties, to have more familiarity with this work rule that you just cited?
So ED5 is a policy on harassment and discrimination, and we have a whole nother section in HR that handles those type of complaints and such. So when a complaint comes in, as a supervisor, I have a responsibility to follow what the policy says. I can't even tell you the last time I got a complaint of harassment and discrimination because it's not a focus of my job duties. I will see the harassment and discrimination stuff when it comes in via investigation packet, and that's when I kind of get involved. So my job, me personally, I don't usually get involved in that kind of stuff early on because there's another whole area of HR for DOC that handles harassment and discrimination.
I appreciate that. You learn something new every day. What is that area?
That is the Office of Diversity and Employee Services.
Okay, and they're at the MAT meeting, right?
Yes.
What? Okay.
That was the other person that you missed.
Thank you.
Can you say that one more time?
The ALJ needed to know who the other person
No, I got that. Can
Yeah.
you say the organization one more
Oh,
time?
I'm sorry. The Office of Diversity and Employee Services.
DES.
OATS is
Oh, it's,
what we call it.
thank you.
Yes.
I'm learning. Okay, so how would we know, let me put it another way, are there notes taken at the MAT meeting?
No.
Okay, so is there any document that would help us learn what, if anything, OATS did with respect to trying to prevent harassment from occurring in the future?
I don't know.
Oh, okay. And I just want to be clear again, because I'm not. Is it your testimony here that OATS is the office that's responsible for making sure that discrimination doesn't happen again at the DOC?
No, I wouldn't say that it's their responsibility. I think all the management and supervisor staff have that responsibility.
And that includes you, right?
Yes.
Okay. And today you're not able to point to anything that you did to help prevent this from happening again, right?
I object, that's argumentative.
Yes. It is argumentative. As it was formed.
So my understanding of argumentative is it's not seeking new information, but instead seeks to have the witness agree with an inference or a conclusion. So maybe I was doing that, but I didn't hear that.
Kind of the way it came across with the verbiage that you used. You're welcome to rephrase, sir.
Sure, but I just want to be clear that my understanding of argument to TIV is not being making an argument with the witness. Because that's part of what I'm doing here in cross-examination.
No,
Right.
no,
I don't.
no.
I'm wondering if everybody has the same understanding. But
I would hope so.
Okay. So, we'll go to another area, though. I believe you said that there was 5 serious acts of misconduct in the statute and then additional 9. That's DOC specific. Is that true?
It's actually the opposite.
Okay.
There's 9 in statute and 5 that are DOC specific.
Okay. So when I look at work rule, I believe it's 2, I see the statute, and I'm sorry, this is not meant to be a trick question. I understand that you're not. What I'm really asking you is, can you show us in R2 where the DOC specific ones are? Thank you.
I cannot in R2.
Oh, okay. And that, again, it's not meant to, but can you explain to us why not?
Because this is the DPM Wisconsin Human Resource Handbook chapter, so this is the guidance document for all agencies and not DOC specific.
That explains it. Okay. And have you been, I'm going to ask this a different question then. Have you been shown here today a document that has the specific DOC work rules in it?
I've been shown the DOC work rules, but not the DOC specific serious acts.
I got it. Okay. And just for me being a sort of a nerd here, I've heard this say serious acts and I've heard it say gross acts. Do you believe that those are synonyms?
I would say yes, and I don't know who would call it gross acts because I haven't heard that statement before.
Okay. I appreciate that. That might have just been for me, but we'll go from there. Okay. Okay. Would you please go to Exhibit 27? Are you able to identify this exhibit?
It looks like an email chain.
Okay. And I'm going to point you to the bottom of the first page there because I believe that's where it's copied to you. Do you see that there?
Is that the respondent's number?
Number 27, R27.
Does anybody have a Bates number?
I think is it?
I've been locked out of my computer system. 'I've been trying to
1497.
email people to find out why I'm now locked out, to no avail. So if somebody could please just,
It's
1497.
Thank you very much.
1497, did we not already put that in?
I thought it was. That's why I wasn't even
We can
pausing
hand it
here.
over here.
Okay, I just want to verify my list.
I'll look for it for another way too.
No, you're fine, sir.
Okay.
I just want to make sure.
Well, we're just trying to get the Bates numbers. Do we have that? Are we good?
Yeah.
Okay, great.
Yeah, we do. Okay, all right, it was, what tab under R?
R27.
Tab R27, and the Bates number would be,
I think that this is it. I put
Yep.
these on there, but I think it's 1497.
do we know how far we're going, Attorney Cross?
It's only 3 pages, or 2 pages, so I think we're at the bottom of this. We're in the middle there.
Of 1499? Okay. And the title of that is,
Respondents Exhibit 27.
and what are we calling it?
Preston email.
Preston
February,
email?
February 26th.
All right. I'm going to mark this as complainant exhibit. That's who's bringing it up. Sir, this is going to be your number 6. So this is going to be complainant exhibit 6, Bates number 1497 through 1499, and this is a Preston email. Do we have a date?
I said, sorry, February 26th, 2020.
2/26/20. Is it a thread or just an email?
It's a thread.
To who?
Originally to Mr. Sonnenberg.
To Sonnenberg.
Yeah, Sonneberg.
Actually, the first email on here is from the victim witness coordinator at the Dodge County DA's office to William Pollard, and then he forwarded it on to various people. Chrissy Preston replied.
I don't dispute any of that. It's just I think the convention that we've been using is the latest date on there. On the top.
Yeah, on the top.
Okay.
And then I'm just making a note, and then I'm going to add
Perfect.
all who the thread goes to, just like I did in the last ones. Okay, this has been marked. It's been offered. Any objection from respondent?
No.
Okay.
Okay, hearing no objection, it is now admitted. Attorney Pross, please continue while I look for this.
All right, there's a lot of paperwork sometimes, right? Okay, so this here, are you able to identify this first? And we're going to go from the bottom here. So this is on the top of page 2. And there's this email that starts, "Good afternoon, Warden Pollard." Have you seen that email before?
I can only assume so because I'm copied on it later.
Okay. And ultimately what my question then is going to be is, can you describe what is going on here, just generally speaking, what's going on here in this email? What is the purpose of this communications?
It appears that Dodge County is letting the warden know that they've charged one of his employees.
Okay. And what issue, if anything, did that cause for you?
It didn't cause me any issue.
Issue may be an inartful word. Is it, do you know why you're copied on this email?
Actually, no, I don't.
Okay. Though, Doug Percy at this time, can you explain again who he is?
He was the assistant division administrator for DAI.
Okay. And then this Mr. Pollard, do you know who he would have been?
Bill Pollard at the time was probably the warden.
Okay. Two more of these. Chrissy Preston, do you know who she was at that time?
Internal Affairs Director.
Okay. And she would have been the person conducting in charge of the Internal Affairs investigation. Is that fair?
She could have been. I don't know.
Do you know if there's another director of Internal Affairs?
She's the director. I just don't know if she was the one that actually did the investigation.
I appreciate that answer. But she would have been the one supervising the people who were doing the investigation.
Yes.
We can be sure of that?
Yes.
Okay. Then, finally, this Catherine Tabbitt. Can you identify that person?
Yeah, she works for me.
Oh, that's pretty simple then. So just to be clarified, she works in employee relations under you. Do you know what job, if any, she would be doing in here?
She would have been copied probably. Now I'm guessing. She was assigned to Dodge and still is currently assigned to Dodge. So she reviews all of their investigation packets. So it's the warden letting her know.
Okay.
Is my understanding of this email.
Okay. And then you had some testimony before that if there was a restraining order or something along those lines, then you guys would have to act. I don't see a restraining order in here, but it seems like there's some action. Can you explain that to me?
It appears there was some conversation of putting Mr. Touton on administrative leave.
Okay. Also, I see here on the second page, this is 2 lines down at the end there. It says, "We will be asking for a no-contact condition of the bond." And that's from the Dodge County person to the warden, right?
Yes, that's
Okay.
what it says.
Do you know what effect there being a no-contact condition of the bond would have, would cause the DOC to do?
Without the specific bond conditions and knowing schedules, no, I can't answer that question.
Fair enough. Do you believe that the DOC moved Mr. Touton to another institution because of Ms. Stolar's internal DOC complaints, or because of the criminal complaints, or some other reason?
I don't know.
Okay. And let me put it this, lastly on this subject here, other than you being copied on this email, do you have any other connection with the decision to move Mr. Touton to another institution?
No, I didn't.
Okay. Now, I think you said earlier that there was a ticket issued to Mr. Teutons?
That's my understanding, yes.
Okay. And when I look at the skip and progression rules, there are there's one of the rules is off duty and there's criminal activity, right?
Yes.
Okay. And but it has to be, excuse me, it has to be more than criminal activity. There has to be a conviction of some kind, right?
That's part of the 9 that are in statute.
Okay.
The DOC has one that says you don't need to be convicted.
Great. I appreciate that. Do you paraphrase that rule for us pretty much?
So the Serious Act for the DOC specific says if you are charged with an off-duty, with something off-duty, we could request a skip and progression at that point if you wanted to.
Okay. And I believe that that document is not in front of you, but are you able to identify with a number or any other thing that would tell us what you just referenced, I'm going to mix it up, the 5 or the 9, but I believe it's 5 from the DOC extra work rules. Can you give us some indication of how we can find that document?
Executive Directive 2.
Oh, okay. But I'm now then confused. Isn't that what is Exhibit R2 that we just discussed? And I may be wrong. Oh, that's Chapter 410, right?
Correct.
And those are not the same thing, obviously.
They are not the
somebody
same
would
thing.
know that. Okay. Who's not just learning. Okay. I appreciate that. I think then, then if we looked on the 410, that would also tell us what the serious acts of misconduct are by the statute, right? And I'm going to get...
Should. Yes,
2.
it does.
Okay. And so I see there off-duty... Oh, I may have it. Serious acts of misconduct. This is on page 3 of 4, and then it lists out 9 things, right?
Correct.
And number 7 says a conviction of an employee or a crime or other offense. And then it says subject to civil forfeiture. Did I read that part right?
Yep.
Okay. And do you know if a civil forfeiture and a ticket are the same thing?
I have no idea.
Okay. Do you think anybody... And there was a lawyer, though, at the MAT meeting, right?
Correct.
Okay. Do you know that lawyer's name?
I'm gonna just put in an objection, a standing objection, that we're not getting into any discussions about any attorney-client privilege communications during this MAT meeting.
Yeah, I thought I had already made that pretty clear.
And probably didn't have to.
And I don't think he had to. I think the question was simply if she knew what the lawyer's name was or not. I don't see where an attorney's name is privileged when they're participating part of these things. But obviously anything that was communicated to that attorney and that attorney's opinions and advice as legal counsel would be.
I think we can all agree on that. I hope we can all agree on that.
Me too. So
Great.
if you know the name, I don't know anybody's names, obviously. I think we've made that very clear in the last 6 days. And I apologize. I stay in my lane. I don't know. You can say the name, but that's it.
Andrea Olmanson.
Okay.
In this particular case.
Andrea sits on the MAT meetings.
On all of the cases?
So, Judge, I'm going to have to renew my this. I can't believe that was never disclosed to us until now, and I'm obviously going to have to renew my motion, and we're going to have to I hope consider the previous decision that she can't testify here. This explains everything. This explains the last 6 months of my life being hell, because of course she's personally interested in it because she's a fact witness. This is. I'm going to need 5 minutes, Judge. I can't believe it. I can believe it, but I shouldn't have to. So, and just so you understand what's going on here is that this person has been a witness to this case the entire time and not divulged it.
Please stop. Please stop.
Unbelievable.
for this particular MAT meeting involving Mr. Touton, or Officer Touton, or Corrections Officer, whatever the proper title is.
Unbelievable.
There's always some type of attorney on these meetings.
Yes.
Correct.
Judge, I need 5 minutes.
You can take a few minutes. I need to digest some things as well.
Unbelievable.
Does anybody know what that page of that routing? We're going to take a break. Okay, we are back on the record. The appearances are the same. Miss Kelly Brown is still under oath. Attorney Hitchcock Cross needed to step out of the room for a moment. He is back in. Attorney Almanson wants to put something briefly on the record, and then I have several questions. Attorney Almanson.
Okay. I have this letter. I mean, first of all, there have been no lies. That's a misstatement. If attorney, I have repeatedly suggested that Attorney Cross contact the lawyer-to-lawyer directory if he needs assistance with his case. It is not my job to tell him what interrogatories he should be sending. If he wanted to send the interrogatories that would have elicited this, he should have. When I in this in any event, there's been no lie. I could hear him yelling on the phone about we don't consent to being lied to, or I don't consent to being lied to, or something like that. But he could have simply sent proper interrogatories and asked who all was involved. What were the considerations? And he didn't.
Judge, that wasn't a record, but let's be clear. I don't think that this attorney is aware of her duty of candor. More importantly, I don't think she's aware of the fact that she is a witness in this case. And she has argued repeatedly that she's not a witness in this case, and that somehow I have the duty to determine whether or not we raised this specific issue on Monday morning at quite some length, and you asked them point blank, were they answering these questions on information and belief or not? You asked them straight out, and they straight out told you things that were not true.
No, those were the answers to those particular interrogatories. Those were under information and belief.
That was fact specific for the interrogatories based on those motions, and that I agree for that. My question here is, and this is on the record, my question is to Ms. Brown, if you know, during these MAP meetings, we have stated that following individuals are present, and I'm going to go through them again. We would have Ms. Beyer, whoever the Internal Affairs Director is, some representative from legal counsel, as well as, and I didn't get the name, but now I have it, as far as the title goes, so let me get to where I just wrote that down, and that is somebody from the Office of Diversity and Employee Services is also at the MET meeting, correct?
And myself included, yes.
Yeah, I had you in there too. Because you facilitated and run, and those are interchangeable terms to you. Okay? All right. And you send out your summaries, usually Friday because the meetings happen on a Monday. Okay. So, during these MAT meetings, and this is a yes or no, during these MAT meetings, is the Office of Legal Counsel providing advice as to any of the decisions or suggestions or things that people have come up with in terms of what they think should happen, the recommendations?
Yes.
Okay. Does the Office of Legal Counsel sign off or participate in the routing slips that I keep hearing about that says where everybody signs off on a given explanation? Do they participate in that?
No.
During this particular investigation with Mr. Toutant, were they there as in their capacity as legal counsel during that MAT meeting?
Yes.
You know she has to be disqualified. You know she has to be disqualified.
I mean, she can't, we can't even undo what's happened here. She is a straight up fact witness in this case. The fact that she was not candid with us about it is not even an issue right now. That's for other bodies. What really is the issue is that we've sit here and wasted an entire I mean, of course she's going to all these threatening my license, my family, my clients, everybody, because she's defending her own personal decision in this case.
Well, I think we've just had testimony that she doesn't make any decisions. She gives legal advice. Her client is the Department of Corrections. I'm sure that legal counsel for a variety of agencies sits in on meetings and gives legal advice. That doesn't mean they're the ones that make the final decision making.
It does make them a witness, which is the issue here. She's
Not-
a witness.
Not if it's attorney-client privilege. You have to breach that. You have to be able to show, and you have the cases, you have the case law.
I'm sure I got the case law.
That tell you that it's a high burden, and you have to come to show that there is nothing that you've done your due diligence, and there is no other means to get this information but by breaching this privilege.
We're not even there yet because there's not an establishment of what there is just a witness. There's not any testimony that she gave advice, that she didn't give advice. She's there participating. The testimony is that she is there participating in the decision. That's from this witness, and that's from Carrie Beyer as well. That we had this discussion with her. She said that legal doesn't, who outranks, legal or you? Remember that testimony?
Yes, and
Yeah.
she said her boss, Carrie Beyer, does.
Uh-huh.
And I just
No,
asked her
from
under...
Carrie Beyer's testimony. You asked her a leading question, and moreover, what I'm saying is Carrie Beyer testified that the legal person takes part in the decision making. That's what the issue is. It's the decision, not the advice. There's nothing in here about advice. It's decision making.
According to the person who facilitates and coordinates, that's the very first question I asked her. Do they participate are they part of the decision, part of the routing, they make a decision, or are they there as legal counsel provide advice? No, now I'm going back to see what Ms. Beyer's testimony was. And I agree. We need quite a bit to look at. So we're going to start.
Judge, it's 4:30.
I understand that.
I think we should get the recordings to everybody so that I can make formal motions and get this all cleared out here.
Well, everything
because-
that's been recorded up except for yesterday has already been uploaded to where it needs to go. Once it's uploaded up to that drive, it is out of my hands. I don't send recordings to parties. There's another process that goes through that, but they've all been there because you asked for it as soon as possible. I did them while I was at the hotel at nighttime, and they're in the file where they're supposed to be. Not in the file, they're in the whatever drive that staff then gets them from when somebody makes a request to staff to do it. I don't provide recordings. I wouldn't even begin to know how to do it.
Well, I'll have a few more questions for this issue, witness on this issue, but then otherwise my suggestion is that we adjourn.
Oh, we're going to adjourn at 5 o'clock because I've got some other things that I need to look at. And one of which is most definitely going to be the testimony that we heard from Ms. Byer. But unless I have somebody saying that there's a difference between legal advice and there's a difference between making the decision, and everybody in this room should be aware of that.
Recommendation is the word that they use, testified to, Judge. Recommendation.
Well, I'm going to have to go back and I'm going to have to listen to that now, aren't I?
I think we all are.
Exactly.
So, but just for my clarification, what I understood was that you said that you've removed several of the recordings to another location.
It's what I have to do because this thing fills up.
I appreciate that, Judge. If you allow me to finish, my next point was that, though, I also understand that they're not available on the portal yet. It was that part.
I don't believe they're ever put on the portal, the recordings.
Okay.
Those are kept on a network drive because IT then does whatever magic they do to make sure, one, they're not corrupted, two, they play, and then somehow they get converted to maybe a CD or a DVD.
Okay, I understand. I may have misspoke. All I wanted to make sure is that they're not on their device, but they're also not available to the parties yet. That's what I meant to ask.
Everything is on, yes, and their entire, I don't think so.
Okay.
I think what they wait is until I have the entire hearing, and then they work their magic and do whatever it is.
Because
Because I upload them every night.
Right. And I'm always suggesting here that this issue is of significant gravity, that I think we may need to have some written briefing on this and the benefit of the testimony that's come before us. I appreciate that you have your notes here, but I think that in all fairness here, I'm going to have to extensively get into this issue here. And I think we need the opportunity to do that. They'll obviously need the opportunity to respond and like that, but I think this is... we're in pretty fundamental territory.
Well, I'm going to make some rulings right now, and I want everybody to pay close attention to these rulings.
Well,
No, please let me finish because I really, really, really just want to. One is there have been oral motions made throughout this 6 days by both parties. They're on the record. Ones that require me to make a decision on was the frivolous sanctions motion that was done orally, timely, by Attorney Hitchcock Cross. I've already said that's going to be in the ultimate decision. And Attorney Almanson was given the opportunity to file a response. The respondent was make sure to get it to me by Thursday by 4:30. We now have this issue that has come up. We are well beyond the motion date. However, as I explained on day one, while I may have a deadline for written motions, oral motions by statute can be at any moment in time. So that means they supersede any written hearing I have, order I have. So you've made your motion. Now, you've made the motion. I think the respondent has heard what the motion is. So obviously you're going to get 14 days, but nobody knows what is in the motion. I'm assuming you would like to put time to put this in writing, sir?
Please, if you'll give us that opportunity, I think that was another motion that I made, was basically for the opportunity to address this in writing for both sides.
And I agree with you. That's what I'm saying. I need to make some decisions here. When do you feel, and I'm not waiting 6 months for this thing.
No, ma'am.
When do you feel, because obviously tonight I will make sure this is in the network universe drive that all of these recordings have to go into. I will have that, depending on what time I get home tonight, it would be in there by tomorrow.
I understand. My
Okay,
proposal.
okay, so that'll be there.
Okay,
I don't know when it's going to be available to the parties.
I understand.
So I need a conceivable, realistic date because everybody knows I'm loath to give people extensions. So we start with your date, and how much time do you think you're going to need once those downloads are available to you, sir?
Thank you, Judge. My proposal is that we follow the same rule that we've done before. The moment those things, the videos or the audio is available to the parties, 14 days to respond. If that's too long, I'd be happy to. We could think something shorter.
I'm happy with the 14 days. I think that's fine because obviously I'm also going to have to, we're going to have to continue this case in some manner, one way or the other. So we obviously need to figure out another date or several that I then need to send proper 30-day notice out as far as that goes. So just everybody know, I will send notice. I know Attorney Hitchcock Cross said he was pretty swamped all the way up until mid-November. That's why we did the fees and costs date for November 21st. Don't hold my breath, or whatever that Friday was of that week. I think it was 21st, 22nd. I'm not sure. For that fees costs thing, in terms of that. You made your motion. She has to respond to that by Thursday. I've only given her 48 hours. Okay? That's it. And then I will take that information and that I will incorporate that into the all-ups merits unless something supersedes all of this and this is all for naught. I don't know that yet.
Okay.
But that's the tentative plan.
Can I make one suggestion?
Okay.
Okay. We are talking about continuing this hearing. It seems like that's inevitable given the time frame. My suggestion is that the parties meet before that we have a scheduling conference or whatever else we want to do and address and see if we can narrow any issues, limit any witnesses, anything prior to that, prior to us having a conference with everybody, and then make that decision.
Well, I haven't restricted anybody's witnesses. Back in March, we had like 40 some. I think everybody had like 20 this, 20 that. I asked the parties days ago to please review your witness list and let's see if each witness is really necessary. If you've got 2 witnesses that have a different twist on or add to a testimony, that's fine. But if you got 34 people that are going to tell me it is raining outside, 1 will suffice. I'm going to leave that to everybody else, but what I am going to do is, it's going to be a teleconference. I have the right to call a teleconference. Mm-hmm. I don't want to hear any grief about what it is. It's just a telephone conference. Only telephone I own is my cell phone. I do not do work on my cell phone. Okay? So the only way I can hold a telephone conference is I have to use my state computer and call people through Teams. That is how it works. I do not have a telephone in my office in Milwaukee. I do not have a telephone in my office at home. I do not use my phone for work things, and I'm not about to start now. So that's how that goes. That's why teleconferences and pre-hearing conferences are done by teams. For me, okay?
So, sorry, Judge. This is the point I'm trying to make.
What?
I think that some people are, not for that conference, but for other conferences, continuing the hearing, do we want to do this by video? Do we want to do it in person? I'm saying I think that maybe there might be some room for doing it not in person, but we should probably discuss that. I'm not trying to limit their witnesses or anything else, but I'm saying if we want to have that discussion, I think we should have that discussion.
I'm amenable to all kinds of things of how we're going to continue this hearing. Okay?
That was my suggestion only, and I understand I got everything that you said. I got what you're saying about the telephone conference, everything else. I'm just saying I think there's this issue here, and we haven't conceded it, that in a continuation would be held somewhere other than in person. Obviously, we don't like the reception that we've received here. Nothing personal, Mr. Anderson, but we don't like it. So it's been highly prejudicial and interfered with my ability to put on this case.
Okay. Well,
but if there would be, we would need to have some kind of discussion prior to anything other than holding this in person.
okay. Well, I'll hear from people as to the manner in which we will continue this hearing. At this point in this case, the complainant has rested. We are now on the respondent's portion. However, we have a motion that's been raised that needs to be addressed before we even move anywhere going forward. All right? Can I excuse Ms. Brown for the day?
I would like to ask her a few more questions on this issue here that we're about to write a motion on. I think it's probably better to get it straight from her than from the record here. How about just a few more?
Oh. I'm gonna limit you till 5.
Oh, that'll be just fine. Thank you.
Okay?
Okay. Great.
And she either knows things or she doesn't know things.
Great, but let's let her have that opportunity.
Exactly.
Okay. So, Ms. Brown, at this MAT meeting, Ms. Olmanson is always there, correct?
Most of the time,
Okay. But is there another attorney that's not Ms. Olmanson?
if she's not available,
Okay. Is it Mr. Card ever been at any of these meetings that you know of?
not that I recall.
Okay. Now, is my understanding the purpose of this meeting is to develop a recommendation? Is that true?
We provide advice for Ms. Wire, yes.
Okay. And ultimately, that advice is called a recommendation. Is that fair?
Well, it's for her to base her recommendation, yes.
Okay. And what is your role at that meeting?
Again, I facilitate the meeting and make sure we talk about the cases that need to be talked about.
Okay. And what's Ms. Byers' role at that meeting?
So, she's listening to the discussion that we're having regarding the cases.
Okay. And does she take in information at that point, or what's going on?
Well, it's a discussion, so we're meeting and talking about the cases, what's the best, like, what recommendations, what are our comparable cases, what have we done in other things, I mean, that's what the meeting's about.
Okay, and everybody in that meeting is participating in that?
Most of the time, yeah.
Okay. Well, when are they not participating in that?
They're all participating.
Okay. And is there any time that anybody in that meeting is excluded from any parts of the meeting? No, okay. So everybody at the meeting is discussing the entire meeting?
No, not everybody's talking the entire meeting, if that's.
No, I'm sorry, that's not what I mean. For example, sometimes there'll be a portion of a meeting where some set of the meeting is participating in the meeting, and then for another portion of the meeting, other people might be excused. Is there any time in the MAT meeting that anybody's excused?
Not that I remember,
Okay. And that would include Ms. Olmanson, right?
unless she had to take a phone call or go to another meeting.
I understand, but she's not, there's no point in time when the legal is not made a part of it, right?
Correct.
Okay. And is there a vote taken there?
No.
Okay, how do you know what the ultimate recommendation is?
How do you know, scratch that, how do you know how people feel about the recommendation?
We're talking about it.
Okay, and is your experience that everybody's talking about it?
Not everybody says something about every case every time. No.
Right, okay, and I can accept that. But generally speaking, everybody's participating in the meeting, right?
Generally speaking, yes.
Okay, and by your experience, everybody's prepared for that meeting?
Like a knowledge objection.
Well, do you get a packet before you go to the meeting?
Myself, yes, I get a copy of the entire packet.
Mhm.
The participants at the MAP meeting only get a copy of the summary.
Okay, how do you know they get the copy of the summary?
I send it to them.
Okay, and that would be Ms. Olmanson too, right?
Correct.
Okay. And at any time when she sends the summary, are you getting legal advice back from Ms. Olmanson?
No.
No. Okay. Is there any part of the meeting that's reserved for Ms. Olmanson to give legal advice?
No.
Okay. I don't think I have any more questions on this subject, Judge. I will obviously have more questions for this witness, but I feel like she could be excused for today.
Do you have any redirect on just what we've done here thus far on cross?
I would object to Ms. Olmanson asking any questions.
Well, it's not her witness.
Right.
Okay? We're not tag teaming, and I've insisted that we don't tag team. It's Ms. Sicard's witness, so I just need to know if you have any redirect on what's gone on so far on cross. And I am reserving that Attorney Hitchcock Cross has not completed his cross, but I at least want to get through this part.
Yes, ma'am.
Now, you had indicated previously that you participate in help with revising human resources policies and executive directives.
Correct.
Have there been any revisions of Executive Directive 2 since the Teutons investigation?
Oh, I don't know.
I'm sorry, I need to try to find this document.
I don't know if it's in that packet,
You know.
but,
Sorry, I'm trying to see if I have, just to double check.
Take your time.
It's,
People get more flustered and miss things when they're trying to rush, okay?
could I direct your, I can't find it right now, but can I direct your, I'm gonna, attention to, it is, I think it's R6 in that booklet. I believe you've already testified about that document.
This is, hold on. This is Respondent Exhibit 6, which is 1162. I think there was some. Let me make sure we have it properly labeled, please. Yes, we did. It's Respondent's Exhibit number 56. It's Executive Directive number 43. It was marked, offered, and admitted without objection. Bates numbers 1162 through 1164. Yes. Yeah, because 6-4 had the serious misconduct. And the double-sided pages.
I just wanted to clarify something, Judge, if we could.
It's your redirect, yeah.
Well, I just want to know, are we just doing,
It's redirect on her,
period.
on
okay,
the cross-examination thus far conducted
okay.
by Attorney Hitchcock Cross. I want that portion done. Because then when we come back, if we come back, Attorney Cross is going to have the opportunity to finish cross-examining Ms. Brown. And then at that point, you will then have an opportunity for another redirect of what happens at that time.
Okay.
This is going to be a delay between people, so I'd like to wrap up. So we're essentially starting anew
Okay.
again, because it's just so hard for attorneys to pick up where they left off.
That's my understanding. Thank you, Judge.
So I don't know if that's normal or what's allowed, but that's what I'm doing.
I just want,
It just makes sense to me.
okay, so Ms. Brown, could I please direct your attention to page 2 of that document? And I think you had indicated that this was, number 25 was the work rule violation that was found for Mr. Toutant.
Yes.
Is that right? And to be clear, was this case, did this case fit under a serious act of misconduct?
I don't recall if one was identified or not, but it ultimately was not included.
Are you familiar with the definition of what a management advisory team is?
From our executive directive, I mean, it's in executive directive 2 of what the management advisory team is.
Okay. Is it your understanding that this team doesn't have any authority or power?
I would agree.
Okay. And can any one member of the team provide, I guess, basically outvote anybody else? And strike that, let me rephrase that. Is this just for providing advice to Ms. Byer?
Yes.
And just to clarify, you said that team members are provided with a summary, is that right?
Correct.
Is that summary similar to the one that you testified about today?
Yes, it's the 15807Fs for whatever cases we're reviewing.
15807
F.
F.
And Frank.
Yeah, there's tons of these forms. Okay. So all the team members are just giving a, that's what the thing you mail out
Correct.
is the summary.
Correct.
Okay.
So the summary was 1 or 2 pages. Is that a typical summary?
Objection leading.
It is a leading question the way it was phrased. We can rephrase it. You've got 11 minutes. I'm going to ask the question. The summary that you've already testified to in the packet, is that indicative of the size of summaries normally done?
They're usually one pages, they could be two. It's usually not more than two.
So they fluctuate.
Yeah.
Fair to say.
It can, you make a recommendation that is higher than, what it, let me start over. So, in this case, you indicated that this was, not a skip in progression, but, the regular process. Can the MAT team provide a recommendation that exceeds what is progressive discipline?
If they can, and if there's a serious act of misconduct already identified, then no additional work would need to be done as far as the investigation portion goes. That recommendation can be given to the Secretary's office by Carrie Beyer. If a serious act of misconduct had not been identified thus far and the MAT team felt like it should be a skip, we would have to go back and redo another pre-disciplinary meeting with the employee.
And at least here, the recommendation was to just move forward with progressive discipline.
Correct.
Can I ask a clarifying question? When you say if the entire MAT team disagrees with what they were given, you're saying it has to go back to another investigation? Would that go back to one of those very beginning stages we talked about?
It would just go, so they wouldn't have to do like another investigation over, they would just need to give notice, these are the work rules, and we are adding a serious act of misconduct, and the employee has a chance to provide mitigation. So they're just doing that pre-disciplinary meeting again.
Got it, okay. So it's not a completely new investigation, it's
Correct.
just a new employee, what is it called again?
Pre-disciplinary meeting?
Okay.
Sorry, I'm just looking through my notes. I had something now I can't find it. I just wanted to clarify, why was DPM not involved in this case?
There was not a request to skip progression.
I don't have any further questions.
Okay. All right. Miss Brown, you are excused. I'll swear you in again at a later time. When you come back again, if we come back again. So we're done for today. This was respondent's witness, so my expectation is if that we do come back, respondent will be the one responsible for ensuring the appearance of Miss Brown. Okay? I'm not going to require you subpoena anyone
I appreciate
because
it.
we're still in the process of cross. And that's kind of where we're at. Because we're in the middle of your testimony, I don't want you discussing your testimony with any other potential witnesses or anybody else or anyone.
And so
Okay.
that means me, but it also means them too as well, right?
At this point, I'm going to exclude her from speaking to anyone else involved in this case. Obviously, she's had some materials that she has reviewed. She still has that packet of materials, I'm hoping. She can continue to review what she was already given prior to. That I don't have an issue with that. But I do have an issue with people talking to people in between testimony. Again, I could be completely wrong, and I'm more than welcome for a court to educate me. It does not hurt my pride at all. But I like to sequester witnesses, and if we're in the middle of testimony, even if this had been, his client, okay, it doesn't matter who it is. We're done. Conversation should have happened a long time ago. Okay, so that's my ruling. I'm more than happy to hear any objections to what I have.
No
Keep forgetting.
objections. I was going to ask for that.
Okay.
Can I just ask a clarifying question? I
Yes.
completely agree that no one is going to talk to Ms. Brown about this case. However, there are only 4 attorneys that work for the DOC, and we may need to talk to this individual about other cases.
Oh, that's fine.
No objection.
No.
I think we've got more than 4 of us, don't we?
Well,
Okay. No, look. Okay? We are all officers of the court. And I am very big on rules and ethics, and I am. Okay? My expectation is that everyone follows those. If you find, and I believe I've directed everybody in this room, you find somebody's not doing what they're supposed to do, my expectation is that you call Stolar. Because trust me, I've done it as an attorney. Okay? I'm not babysitting you guys, okay? I'm hoping we can all be adults here. But obviously, you could talk to her about what she had for lunch, another case that is completely unrelated to this. But it has any tie to this case. Anyone who may potentially be a witness in this case. You know who the witness lists are. You've exchanged them amongst yourselves. Any exhibits, any of that kind of stuff, that is off limits. Does that make sense?
yes.
Okay. I realize it may be difficult, but I think parties are in a difficult position right now. And I've got a lot of case law that I need to research. I need to listen to all these tapes. I need to I need to read a motion that's coming as soon as these recordings are done. And then I need to read another response, 14 days later, starting with that. In the meantime, I've got 92 cases on my docket. I've got another 5 hearings every week for the next 3 or 4 weeks. I've got decisions I have to write. It sounds like I'm whining, but that's just my life, okay? I have no problems working at night, and I don't want to hear anybody telling me why am I working after hours ever again. That's my business. I'm a state employee. I get paid for 40 hours a week. If I want to work 92, that's on me. That's just how it works. So, whatever. I'm not asking for pay. But I do like to get things done. So, everybody keep that in mind with what you write, okay? And I will read them as soon as I can. I log it into the file, and then I wait. And I might even put the header and start making a template of what I'm going to do, just because some of the beginning of how the case came to be is what it is. But as far as the things go, I don't do that until I've heard from both sides, and then I read them. Any questions about what we're going to do? Any objections as to what we're going to do? Please let me know if you disagree with what I'm saying right now. Okay? Everybody's entitled to their opinion. If you think I'm screwing up, please let me know right now.
I just wanted to clarify, we may need to contact her for availability for hearing if we get that far, so.
Oh, that goes without saying. I'm expecting you to ask that. I mean, any objection? No. I mean, that's kind of a common sensey thing. What I don't want is this case discussed. But obviously, look, these are the dates we're looking at for coming back. How does that work? Because it doesn't mean no good to calendar something. And then I hear from everybody, I've got a deposition up north. I've got this, because I will give everybody a variety of dates. I expect you to check with whoever you need to check with, including the remainder of your witnesses if you have any. Let's get it all wrapped up, because when we come back, however we come back, I want to make sure we can actually finish this case so that then people can get busy once the final recording of whatever those last few days are in writing their post-hearing briefs, if we get to that point. Sound good? Okay.
We've done some good work today.
All right. Anything else anybody requires of me?
No.
No? Okay. So you're like not under oathy anymore, but you will be back under oathy when you come back. Okay? And if anybody says anything, you can just tell them I'm this horrible, evil person that swore you to not talk to anybody, and I'll wear that badge proudly. All right? I never have any problem with people throwing me under the bus. Don't care. All right? That's how we roll. Okay? All right. Anything else? Because I'm going off the record.
They can hold you to all that?
Yeah, I don't really